some urgency is there, my lord.
Mention on Monday, please.
Well, one
Yes.
urgent matter, my lord. 26th is the program. It's in Jalsha. Jalsha is Islamic Jalsha religious festival, my lord. Police has not granted the permission. Police has refused that, saying that it's a program connected with the religion. Verbally, they have refused yesterday, my lord. 26th is the program. Any day, my lord, according to your lordship's convenience.
Any day means
Any day. If
today,
you
2 days is 20th.
20th.
26th.
26th is, my lord. 23rd. 4th. Next Wednesday. Next Wednesday, my lord. Any day.
24th.
24th. Grateful, my lord.
My lord, under extraneous circumstances,
Monday.
I beseech,
Monday.
my lord, it's not a mentioning, my lord.
Yes.
There are certain events that has taken place yesterday night. There is one writ petition which is pending before my lord's court, item number 71, in which my lord was pleased to direct the state authorities to file a further report. My lord, yesterday night, the petitioner has been arrested in connection with a fresh case which has been filed after filing of the writ petition. And what is most important is that, my lord, the letter of complaint is the
Steps
identical.
in accordance with law. Yes, please call the list.
My lord, on 15th, I have made a representation, my lord, that I want to hold a program on 19th. Now they have via email they have let us know that on 17th they have let us know that on 19th there is another program on the same premises. Now, my lord, I have on 17th again I have made a representation that I want to hold a program on 20th. Which is today, my lord. And they on 19th, last night at after 9 p.m., my lord, they have let us know that on 20 to 24 there is another program. So they are constantly doing this, my lord. Kindly grant me leave so that, my lord.
File it, let it come. No, you are deferring this program, then wait for some time. Please call the list.
Deferring this program.
File it,
Item number
let
one.
it come under the heading motion, then mention. Please call the list.
My lord, kindly.
Sorry, refused. Yes.
On
Yes, who is appearing in item number 1? Sorry. Yes.
I am for the petitioner, lordship. On the last occasion, your lordship directed us to serve the learned advocate for the respondents, lordship. My lord, I have served, lordship, only.
Why it has come under the heading to be mentioned?
Lordship, it is a hearing matter of 2019, lordship. The lady is suffering maintenance.
Just a minute. No. This matter was mentioned for release.
Lordship,
Now, when this matter was accommodated, nobody appeared on behalf of the petitioner.
lordship, we appeared, lordship. We prayed for an adjournment because the lordship directed us to serve the learned advocates for the respondents, lordship. On the last occasion, we have not served after the mentioning for release. Your
At the
lordship,
time of call, no one appeared. It was only
lordship, the appearance is there for the petitioner, lordship. Your lordship kindly sees.
yes, accommodation was prayed for. Yes.
Accommodation was paid for since the respondents were not put on notice after the mentioning, lordship. Your lordship granted us.
Now, what
liberty
you are
by
praying
the-
for?
I am praying for, if your lordship may kindly pass an order so that I can try my
No, you mentioned this matter for release.
lordship. If your lordship kindly,
So let the matter be released.
I am grateful, lordship.
So it is at the hearing stage.
It is at the hearing stage. It is under the hearing before your lordship.
Issue. Matter is taken up for consideration. Matter appears in the list under the heading to be mentioned in terms of the order dated 10th August 2026, when learned advocate representing the petitioner prays for release of the matter. Since matter needs to be heard immediately in view of urgency. However, court is not satisfied relating to the urgency, and court has refused to hear the matter out of turn.
Mr. Dheeraj Trivedi, Union of India, my lord.
I'm appearing for the state, your lordship.
Union of India and state respondents are represented by learned advocates. Matter stands released. Matter stands released. Stop. Next.
Obliged.
The petitioner
Item number 2. Item number 2, my lord, Mr. Muzumdar is appearing virtually, my lord.
My lord, please permit me to appear virtually, my lord.
Copy of the report.
Pursuant to your lordship's direction, my lord, the marriage has been solemnized and my lord, adequate police protection were given.
That matter, interfaith marriage?
Yes.
Just a minute. তুমি জানো না তোমাদের বিয়ে এই রিপোর্টের কপি Yes, nothing remains.
No, Your Lordship, the marriage has been solemnized.
Uh, in terms of order dated 27 July 2026, a report dated 3rd August 2026 of Inspector in Charge Uluberia Police Station, Howrah, Rural District is placed before this court and same is taken on record. Copy of the said report dated 3rd August 2026 is made over to learned advocate representing petitioner. Next paragraph. It is disclosed in the report dated 3rd August 2026 that in terms of order dated 27 July 2026, a marriage of petitioners was peacefully solemnized on 29 July 2026. In presence of marriage register.
And my lord, adequate police protection were given.
No, it is also disclosed that police assistance is provided to the petitioners at the time of marriage, and concerned police authorities are keeping continuous vigil at the local stop. Next paragraph. In view of steps taken by the concerned police authorities as it emanates from report dated 3rd August 2026, present writ petition stands disposed of. However, concerned police authorities are directed to provide protection to the petitioners if occasion so arises.
Obliged,
Declare.
Item number 3 and 4.
Yes, I cannot hear you.
Item number 3, Mr. Rohit was supposed to lead, but he's fallen very unwell. So he has requested for another. I'll indicate that later. But we also have Mr. Dave, who's flown down from Supreme Court. He's a very, very eminent lawyer, Marat.
Yes,
Your Lordship, he's in item number 4. Your Lordship would hear 3.
No, but since I have found that these are the two matters originating from a same criminal prosecution.
Yes.
That is Ahmed Nagar,
yes,
Ahmed
yes,
Bazar
yes.
Police Station case number so and so.
Yes.
Now, I found that it is necessary to hear this quashing application first. Why I am telling you that if your quashing application survives, if quashing application is allowed, there is no need to hear this application, revisional application.
There's just one difficulty, my lords. Just one difficulty. In item 4, there is attachments which are taking place.
Yes.
Attachments which are taking place
Yes.
pursuant to the proclamation. Now, if those attachments continue to take place, my lords, it's going to cause us
Mr. Dave,
irreparable.
these attachments are subject in terms of the seizure that made on 30th July 2026.
No, my lords, these are, my lords, attachments which are taking place after I'm declared as a proclaimed offender. within a space of 10 days from the non-bailable warrants being issued to this.
That's why court is saying that if that criminal prosecution goes,
Yes,
allowing the 226 application
yes,
under Article 226, application under Article 226,
yes.
then this application will become redundant.
Because I'm only praying, my lords, that if your lordships are inclined to defer the proceedings and hear the quashing first, then no other proceedings continue as far as the item 4 is concerned for the time being, because it will all be set at naught once if your
Oh, that
lordships say,
how can it be?
because this will survive, this 4 will.
That's why on the prayer being made on behalf of the petitioner, Mr. Ruadke mentioned online before this court, matter has been fixed today. What can be done? What more this court can do?
Because I can assist your lordships, my lords, in 3 also, they arise from the same.
This writ petition, this revisional application is required to be heard in the event your application under Article 226 fails.
With respect, your lordship is right, my lords. Your lordship is right, absolutely. But then, my lords, we have certain urgency in our. We can start with there. It's the same FIR. Nothing much turns it there. The facts are the same. We can argue 3 and
That's why
4.
court is also saying that court is minded to hear the quashing a petition first.
All right, my lords. We can start. I can place because it's only a quashing of FIR, my lords. It's nothing so.
Yes.
Copy of the. It has not been served.
Which one?
Which has not been served? Mr. Mitro?
The revisional application.
Oh, that has not been served.
Because I'm told that revisionals are not served till notice is issued in revisions.
Admitted first.
If it is. So that is the practice of your lordship's court.
That is a writ petition.
The writ is there.
So writ is served on them.
Writ is served, but we can't serve it till the time.
Unless you're.
Whatever has happened, my lord, had according to the my lord, the petition in item number 3, my lord, it happened long back. Well, let them serve, and my lord, we can come back on any other day next week.
Lords, long back in quashing.
Well, today, since you have come down from Delhi and matter is fixed for hearing, I will hear you precisely with regard to this revisional application, serve a copy upon him and fix up a date for hearing of the writ petition.
And the writ your lordships are inclined to hear today.
If you intend to move the writ petition, I have no difficulty.
Yes.
Choice is yours.
Yes, we'll move it, my lords. We'll move it, my lords.
Very
We'll
good.
move it.
35, 55. There are other petitions also, I understand. Apart from 3,
There is 3
is being taken up.
35,
35
and 55.
and 55.
Once this matter is taken, heard and order is passed, that will govern the other matters.
Just one leave of your lordship. We're serving a copy.
Of the revisional application, yes, serve a copy.
Though officially it's so that till the time an order is passed, we can't serve a copy. It is supposed to be from now that we are appearing.
Mr. Mitro, accept this service of revisional application.
No difficulty, my lord. Only thing is, my lord, coordinate bench, my lord, had dismissed, my lord, a revisional application before. Same ground.
But this revisional application was released since this writ petition is
It's by another accused, yes, of the same group, my lord.
another another divisional application of the petitioner was dismissed.
Yes.
With leave of Mr. Dave, my lord, I appear here. We challenge, my lord, the arrest of a person who is in custody to whom the ground of arrest was not supplied. So that was the subject matter, my lord. Nothing to do with this petition was no correlation with this.
But in this revisional application also, you have taken the point of section 47, compliance of section 47. I have seen.
Yes, yes.
Yes.
But he's not arrested. So
Very well. Well, Mr. Dave, please move the writ petition fast.
Yes. I'm obliged. My lords, we are constrained to move this, my lords, in the most peculiar circumstances. A police officer, my lords, is on patrolling duty in the hours of 29th of July and 30th. 28th and 29th. Early hours of 29th. He gets at 3:15 a.m. a secret information that in a particular house of a particular person, my lords, there is stashing of cash and of some material, and therefore there is urgency at 3:15 a.m. that the premises be opened and investigation commence. He informs his superior. Superior says yes, do it. Makes a general diary entry at the police station. He doesn't go, but it's done over telephonically. And with the police force, he goes knocking on the house of the present petitioner's brother-in-law. The house is not opened. They use force. They enter. They ask the persons who are there. There are some women. There is the brother-in-law, that we have come. We have information. We want to search your house. All that is done in the early morning, and in the search, they find there are gold bars and cash items which are present there. Some of those items are in boxes, some are in almirahs. Those almirahs are broken open, and then they are seized.
No, items are found, if I am not wrong, from cupboard.
From, yes, almirah, my lords, are where they say the cash, etc. is all stashed. And then there are gold bars also. They call some jeweler to verify whether the gold bars are authentic, etc. And thereafter, my lords, the person, that's the brother-in-law, he is taken to the police station.
After 26 hours.
And he goes to the police station, my lords. And at the police station, his statement is recorded, in which it is a confessional statement which is recorded. All this, my lords, is from the record. Thereafter, my lords, at the police station, an FIR is registered at the police station. All this till the investigation of, till the registration of FIR as investigation has already taken place, which is entry, search and seizure, and arrest. All three acts have taken place before the registration of an FIR. Now, in the confessional statement, and what comes to that, sorry,
I'm interrupting you. Section
No,
under
please.
section 106
yes, madam.
BNSS.
Yes.
Is there any bar if there is no FIR is not subsisting?
No, my lords, not a bar, but in the peculiarity.
6.1 doesn't impose any bar, explicit bar.
No bar, my lords, but in the peculiarity of how it is. Suppose there is a cognizable offense taking place, in the sense why there is no bar, I may explain, my lords. A murder is taking place and an accused runs into a particular house and hides himself. Police officer is there, he has seen that particular act being taken. He then has to open the premises and apprehend that particular accused persons. So an offense has taken place. Here the offense is taking place before, from a source information that this particular police officer is supposed to have. Who has told him? We don't know. And please, when I take your lordships to the FIR, I'm sure your lordships have already gone through it. The FIR is so detailed as far as what was the allegation. There was illegal sand mining, it was happening. Now, there was one preliminary point. Possession of currency notes in my house and gold is not an offense under the IPC. It is only, if at all, an offense under the Income Tax Act. Only the income tax authorities have jurisdiction as far as cash is concerned in a particular house. Then it is upon me to explain to the income tax. And that is why, my lords, your lordships may bear in mind that income tax offences are not as scheduled offences as far as PMLA is also concerned. So if I am found in possession of cash which is beyond my known sources, not in the prevention of corruption sense, but beyond, as a private person, I have cash in my house, my lords, then it is no offense for the police to start investigating that we have found so much
But whether we keep cash in cupboard,
yes, my lords, for safety,
it may not come under the purview of, as you are saying.
yes, my lords.
It does not come under the purview of BNS. Rather,
my
it
lord.
comes under the purview of Income Tax Act.
Lordship, please.
But whether a prudent citizen,
Yes,
or a man of ordinary prudence keeps those items in the cupboard.
yes, my lord, I'll indicate. There are certain business transactions, my lords, in India, which are also primarily based, my lords, on cash transactions. Selling of country-made liquor, my lords, is based on cash transactions, where people come and buy, my lords, for small amounts of money. Those are the things. Here also, as far as mining is concerned, it is there. Now, please, when your lordship sees the FR in the facts of this case, that at 3:15, they could not wait. What is the source information, my lords? Nobody knows about the source information, who this information has come from, that this particular person. And I am not even in that house. Please bear in mind that part, my lords. It is not my house. I'm not even in that house. I'm not even present there.
You have left country on 23rd of May. As you have
So,
stated.
yes, my lord. So I have gone, my lords, on 23rd May. This is happening on 29th of July. And therefore they go to my brother-in-law.
Why you have left country?
I've gone, my lords, to roam around. It's a, my lords, to
Roam around.
roam around, my lords. It's a,
So you have left the country on 23rd of May and this seizure was made.
But they-
Some valuables are, some, not some, huge valuables
all
are
right, my
found.
lords, yes.
And you are saying that this court will exercise extraordinary jurisdiction, which is not a routine procedure
No, I'm-
as contemplated in Niharika infrastructure.
Yes, my lords. I am praying for your lordship's consideration.
And the investigation is at the nation stage.
Lord, the section that has been invoked, section invoked is 111, which is organized crime.
Please come to page 127
of the paper book.
of the writ petition.
Yes. So, my lords, please mark, my lords, as far as quashing is concerned, your lordships will see the ingredients of the offences. The
Please
offense.
come to page 127.
127 is in second one. Yes, my lords.
Please place remarks column
Remarks. my
or
lords.
the
Yes.
narration under the heading remarks.
Yes, my lords. The search and seizure operation was initiated in the early hours of 29/7/26 on the basis of credible source information. The commencement of search was initially delayed to the non-cooperation of the occupants of the house. Upon completion of the necessary legal formalities, the search and seizure proceedings commenced at 5:52 hours on 29/7/26 in the presence of witnesses named herein. The property is 2-floor building with 5 small rooms on each floor. As the search progressed, and substantial quantities of Indian currency and yellow-colored metallic bars were discovered, additional police officers and force was requisitioned and subsequently joined the operation to ensure the safe, systematic and transparent conduct of proceedings. Now, the milords, the persons are mentioned therein.
Yes, yes.
During the search, the seized properties comprising of Indian currency and yellow-colored metallic bars were, there's a stamp, were
Yellow color metallic bars were
recovered principally from two locations within the house, namely cupboards situated on the ground floor and cupboards situated from on the first floor. On the ground floor, one cupboard described under Exhibit V was found containing 25 bags filled with Indian currency note. Each bag was opened individually in the presence of the witnesses. In each bag, handwritten slip indicating amount was found. All such slips have been seized as Exhibit 59. Currency was removed, sorted denomination-wise and counted. Considering the exceptionally large volume of currency recovered, additional currency counting machines were arranged through liaison.
What more is necessary at this stage?
It's not me. Milords, kindly bear in mind, Milords.
But the suspect comes to
He's arrested.
Suspect comes to be true.
He is arrested.
The suspected, the officer, the concerned police official who suspected and entered into the premises in question and recovered, and this appears to be true. True.
No, it appears to be true, Milords, based only on my confession. They have no idea how I've got this. Now, please read that part of the FIR where they say that this is all from the person, what he has indicated. This is the seizure part which your lordships were pleased to read, Milords. Please see the FIR.
No, since the rule, as I follow, having seen the relevant judgments, that if I find that there is a prima facie ingredients are found for investigation, it's not a routine procedure, Mr. Dav.
No,
It's not a routine order which is required to be passed on an application under Article 226 seeking interdiction of High Court in a criminal proceeding.
Lordship,
So therefore, if these ingredients are there, I'm not
Milords,
at all satisfied with regard to the case.
Please allow me to persuade, Milords. I am on the malefides as far as the beginning of the starting of the investigation is concerned. That at 3:15 a.m., who gave them the information that this is there? Obviously, it is not as what is written in the FIR. Your lordships have to see the FIR. Therein
Let
it
the
is
investigation
indicated.
be proceeded with.
No, please see
And
the
at
sections.
this stage, I will not interfere.
Milords, kindly see the sections that is invoked. It can't be invoked. On that, your lordships will see whether that section is made out for a quashing of an FIR.
Whether the sections have been rightly invoked or not,
yes,
that is a separate thing. But there are the ingredients which are there. So let the investigation be carried out.
Look,
And if you find that during course of investigation, these sections were not required to be fastened, in that event, you approach the jurisdictional magistrate.
My lords, in the quashing itself, your lordships have to see, my lords, with respect. Those are the judgments. Whether suppose I am today accused of cheating, and the cases of cheating are there.
And if you are in custody, apply for make an application, move an application under 483.
It's not me. The person who is in custody is there. That is the
and the petitioner. He is in he is out of country. Let him move an application under 483.
Kindly allow me just for a moment.
Why this court will entertain this Article 226 application
Because this
seeking
section
quashment of the proceeding?
My lords, lordship may have a look at section 111 for a moment, my lords. The primary allegation against me is under 111 of the new BNS. 111 is adopted from section 15 of UAPA. Please see, now we have UAPA, which is incorporated under BNS. Those are the offenses of organized crime. Now, this organized crime, my lords, requires that certain charge sheets have to be filed for the invocation of section 111, that certain charge sheets have to be filed 6 months before in cases. Now, if that criteria is not fulfilled, my lord, there is no way that 111 can be invoked. That is one part. They have invoked cheating. Who have I cheated? There is no complaint. It is the police officer who goes, who recovers. There is extortion, not a complaint. Because we have to have some sort of a semblance of the rule of law, as far as not a police officer who is the roaming sheriff, my lords, who goes around entering people's house in early morning 3:15. Kindly see whether those offenses.
And it was things were recovered, valuables were recovered.
Yes, but
that not from the almirah of the person.
The law, my lord,
it is from cupboard.
Lords, I respectfully submit that law is not about proof of the pudding is not in the eating. Merely because I went into it.
At this stage, court is not required to go into this aspect. That will be considered during trial.
Are required to see, my lords, at the stage of quashing whether the ingredients are made out. All judgments on quashing, my lords, from Haji Iqbal, etc., my lord Muhammad Wajid, are on whether ingredients are made out.
Haji Iqbal, paragraph 14 says attending circumstances.
Yes, my lord.
I am not at all satisfied with the attending circumstances.
Circumstances is because, my lords, kindly see, they have, this is a crack of dawn operation. They could not have done it any other way. And therefore, the source information, because they don't even have one complainant before them. Not one.
With regard to incorporation of section 111, you can approach jurisdictional magistrate.
No, Milad, how can I go, Milad? That's why that's why it is before your lordships as far as quashing is concerned. Because all quashing judgments are whether the ingredients from Bhajanda.
Paragraph 33.16 of Niharika infrastructure, it has been succinctly decided by the Supreme Court that when there are preliminary ingredients found,
yes,
this court, while considering writ petition, is not required to find out the veracity of allegations.
Yes.
So therefore, since the investigation is at the nascent stage,
yes,
so therefore, investigation should be permitted to continue.
Yes.
And if you find that you have a case, then move an application under section 482.
Because I'll explain this by way of analogy.
Yes.
Suppose the FIR said murder, also in it, old 302, now 103, my lords. Old 302. And I came before your lordships to argue, my lords, there is no murder that has taken place, my lords. Your lordships court, my lords, under 226 or 482, my lords, would necessarily have to look and ask them that, look, how is this made out? This offense has not taken place. That is precisely what quashing is.
But that does not appeal to this court in view of the huge valuables which were recovered on 29th and 30th.
Lords, 2 points, my lords. Recovery of valuables, again I reiterate, my lords, and resubmit before your lordships, that is not an offense under any of the provisions of BNS. Not one is an offense. Either I can have as much. They should have informed the income tax authorities. Income tax authorities would have come, and income tax authority would have seized the goods and proceeded in the manner they thought best. But till date, income tax is not there. Their allegation is that I'm indulging in illegal sand mining. Now, illegal sand mining, my lords, is covered under the MMDRA Act. It is a complete code by itself. Not one provision of MMDRA Act has been invoked by them. This is completely overreaching the jurisdiction, my lords, of the police. There is nothing more in it. Please have a look at 111, my lords, if that can be invoked at all. And the sections, no.
The petitioner has left the country.
Well, they went in May. They could not have foreseen. There is no FIR. There is no proceeding against me.
And not only this this criminal proceeding, which has been initiated based on the FIR, which is at page 93, rests on 111. There are other sections 316, 316, 5, 318.
Yes. Now,
So
please.
let it be
No,
investigated upon.
I'm obliged to your lordships that it fell from your lordships, my lords. They are relating to offences in 2021. I have a chart with me. I can show to your lordship. Those 6 FIRs that they have mentioned, that we have 6 FIRs against them, relate to an offence has taken place in 2021 according to them. 21, an FIR registered 5 years after that. Obviously, my lords, that is obviously done on the basis. If I can hand over the chart with the summary of those allegations.
This chart is there, page 167.
167, my lord.
Yes. Of your writ petition.
Same chart, my lord, but this is more elaborate.
Come to page 167.
Yes, my lord.
Of your writ petition.
Yes, my lord. I am at 167.
Yes.
No, this doesn't.
The oldest one is 7 July 2025.
No, I know, but
but all are 23rd of May 2026, 1st of June 26, 19th May 26, 4th of July, then 6th of July.
They don't indicate the date of incident, is what I'm saying. That is why I've handed over this. The more details.
This is not a case, Mr. Dave, that that the alleged commission of offence took place 5 years back, and this writ petition is criminal prosecution has been initiated based on FIR.
No, my lord.
It's a seizure was there was a seizure, and this seizure was on 29th of July 2026, and FIR was registered on 30th of July 2026, if I am not wrong.
My FIR is registered on my confessional. 30th July on my confessional statement of the co-accused. It can't be, my lords. That's strictly covered by Agnu Nagesia, where Supreme Court said, my lords, it is barred. You cannot read.
Court is also disturbed because court has to consider the attending circumstances. Rightly, you have pointed out, as it was observed by the Supreme Court in paragraph 14 of Haji Iqbal, that the petitioner is like Indrajit in Ramayana.
Yes.
He is watching the proceedings behind the cloud.
My lords, the paragraph that is falling from your lordships, my lords, I know Haji Iqbal, allow me, my lords, I argued it, so therefore, my lords, I have some nostalgia for that particular.
That is the privilege of this court.
Yes, my lords.
To hear Mr. Dave in this
I'm
matter.
obliged, I'm grateful, my lords. But Haji Iqbal is where it is the malice on part of the investigating agency, then those attending circumstances will be looked at by your lordships. For the first time, my lords, apart from Bhajan Lal, that clause 6 of that at 6, whether there is any malice, my lords, Supreme Court had said, my lords, not to look at, only look at whether offences are made out or not. Now Haji Iqbal opened the door a little, that if it is actuated by malice, then your lordships in 482
but
to
if
26
the petitioner is out of the country, then what order you require?
No, my lords,
You are free there.
No, but my lords, this is my country.
You are free there, Mr. Dave.
My lords, I can understand if after the FIR I had fled, then your lordships may shut the door and say, look, Mr. Dave, your client left without on the jury. I'm already away. I'm not in India. And then the FIR is registered, my lords. And then, my lords, if I come back.
Come to page 167.
167.
Yes, again, let us come to page 167.
Yes, my lords. Uski copy do na wo chart.
On the date petitioner fled, there is an FIR 150/2026 dated 23rd May 2026.
Please see that FIR.
Right? Then please serial number 4, 19th May 2026.
My lords, please see this chart, my lords, that I've handed over. It would shock the conscience of this court, with respect, I'm saying. So if after 21, merely because there are certain changes that take place, my lords, does not entitle the state police.
This matter does not relate to the political change.
It does, my lords. It is borne out by the
because
first
the petitioner
FIR.
is not a political person.
My lords, 167, your lordships may see, the first FIR, which is registered on 19/5/26, is relating to an allegation of 4/5/2021. 2021. How does a person know, my lords, that in something that happened in 21, FIR is going to be registered in 2026?
But I am not on this 19th May 2026 FIR.
Yes, even the other
I am on with regard to Mohammad Bazar police station case number
316
20 that is dated
23/5. That is also relating to an allegation a year earlier. 1 year earlier, my lords, that the complainant had hired a vehicle for 25,000 per trip, and therefore the cheating case is now levied against him.
FIR number 267.
267.
Page 93.
267 is the present one.
Yes.
267 is the present one, but all the other, which is
There in the present one, there is no issue that the incident relates back to to a date of which is that the alleged incident took place 5 years back.
Because there is no incident, there is no date of incident in the present FI. There is no incident.
Very basis of this initiation of proceeding is the seizure.
Milords, yes, so I'm again laboring, Milords, for your lordship's consideration. For criminal law to kick in, there has to be an offense, is what my submission is, Milords. Here, there is no offense. There is a recovery which is not an offense under BNS. Under BNS, it cannot be prosecuted by the police, is my respectful submission. If there is an offense pursuant to which recovery, investigation, etc. takes place, then one can understand, my lords. But here it is the other way around. There is a seizure investigation trying to find an offense. Now, please ask them holding currency notes.
But if we come to section 106, there is no bar.
So
let us come to section 106.
But 106 assumes that there is an offense, my lords.
Let us see.
The entire code of criminal procedure. I'm sorry, my lords, I keep referring back because I'm still not as well conversant with BNSS, my lords.
Yes, 106.
And power is to serve. Any police officer.
Who says so? You are not conversant.
No, with the sections, my lords.
Come to section 106.
Yes, my lords. I'm obliged. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense. Again, my lords, offense. There is no offense. With respect, my lords, what is the offense? Please see. If there is an offense, that's why I'm saying, my lords, how does criminal law kick in? Your lordships are, I don't have to labor on that part before your lordships, my lords. Their jurisdiction comes when there is an offense. They find something, please inform the income tax. Please ask them to go there. Please ask them to see.
What they will do, this court will not direct at this stage.
But
let the investigation and be carried on, and let it be continued.
But my lord, there is no. Please, now while your lordships has the book, my lords, please have 111 of this BNS. Please have 111.
BNSS.
BNS, my lords. BNS. That's the IPC.
BNS.
Yes.
Oh, organized crime.
Organized crime. Please see.
Just. Yes. 111.
Yes, my lords. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber of crimes, trafficking of person, drugs, weapons, illicit good or services, human trafficking for prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute an organized. And please pause here, Milords, for a moment. It talks of a continuing. This is continuing because it's borrowed verbatim from section 15. Now, organized crime means a group of two or more persons who, acting either singly or jointly as a syndicate or gang, indulge in any continuing unlawful activity. Continuing unlawful activity means an activity prohibited by law, which is a cognizable offense, punishable with imprisonment for 3 years or more, undertaken by any person, either singly or jointly, as a member of organized crime syndicate or attempt to commit culpable homicide, organized crime on behalf of such syndicate in respect of which more than one charge sheet has been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense and includes economic offense. Now, please mark this.
This is the definition of continuing unlawful activity.
Yes, my lords. In that, the criteria for invocation is that I should have one charge sheet filed in the previous 10 years on which a court has taken cognizance.
if we go back to section 111 subsection 1,
Yes, my lords.
for my understanding,
Any continuing law,
any continuing unlawful activity including kidnapping,
robbery,
vehicle theft,
yes,
extortion,
yes,
land grabbing,
yes,
contract
Trafficking.
killing, then economic offense.
yes, no doubt.
Yes, then economic offense is also defined separately.
Yes. But continuing,
Criminal breach of trust, forgery, counterfeiting of currency.
yes, that
Now,
comes,
the criminal breach of trust is one of the sections fastened,
no doubt, my lords.
section 716.
But
So why this court is required to confine to the definition as attributed under section 111?
because the
Subsection 1II.
because the offense is of continuing unlawful activity,
Any continuing-
which is organized crime. Organized crime is a continuing unlawful activity. That unlawful activity sub-ingredients are robbery, extortion, etc. But continuing unlawful activity, because it is continuing, is separately defined in Roman 2, by meaning that for it to kick in, necessarily it has to have a charge sheet which is filed in the preceding 10 years on which cognizance is taken. That is a given, my lord. There can't be a quarrel by anyone on this particular proposition.
Including economic offense. Yes.
My lord, so please see this.
So your submission is this continuing unlawful activity includes economic offense.
It
So
does.
therefore, continuing in order to constitute the offense,
Of-
which is to be termed as continuing unlawful activity,
Yes.
then there is a requirement to satisfy the conditions as stipulated under 111(1) II.
Lordship pleases. Because this is an offense which is separate from those sub-ingredients that are mentioned. I can be prosecuted for robbery separately. I can be prosecuted, my lords, for theft, extortion. That as an individual. But if it has,
If in a criminal prosecution, there are several sections fastened
yes, my lord.
or incorporated.
Yes.
Now, out of which, if it is found that one section may not apply in a
Yes.
particular, in a given situation,
Yes.
in that event, that liberty is always there to approach the appropriate forum.
My lords,
For that, you need not approach the.
I will,
In Article 226, I will grant you leave.
my lords, I will address, my lords, and best to my endeavor show none of the sections apply.
No, that I will not.
None.
I will not treat at this time.
My lords, your lordship,
At the nascent stage.
at this stage itself, my lords, they have to be. Because if there is no other stage available to me. Tomorrow, if they file the charge sheet, my lords, the objection will come. Now,
Because
charge
I
sheet.
am not hearing, it is not a trial going on.
No, not a trial.
Let the investigation be carried out.
I am asking your lordship to see it on the face of it. From the FIR, your lordships have seen, which talks about seizure of two kinds of commodities. One is cash and one is gold. On that particular seizure, my lords, your lordships may see as far as whether any of these offences are made out, my lords. That is all that I'm asking your lordships.
Mr. Dave, in that event, I will not, I am not satisfied with regard to passing an interim order. If you pray for, I can direct the parties to exchange pleadings. Otherwise, I have to pass a final order.
No, my lord, then-
Choice is yours.
No, but I bow down, my lords. Of course, I see what is falling from your lordships, my lords. But as far as then, my lords, on a prima facie basis, if I establish this, that I have an arguable case before your lordships, my lords, that I am arguing it, subject to whatever the other side may argue before your lordships today. My revision, which is there also with this, that they are taking steps. I can address that part also before your lordships then. This is an arguable case, though it comes across.
But I don't want to mix up your revisional application with this 226 because the parameters are different and the different scrutiny is required to be considered. Should be resorted to. So therefore, I want to decide this 226 application first.
Even assuming your lordships decide this against me, my lords, for a moment, I take it that your lordships are not inclined in this. Even then, my lords, my revisional petition, I can show to your lordship the manner in which non-bailable warrants are issued and the proclamation is done by placing reliance on two judgments, one of the Honorable Supreme Court and one of your lordship's court, is completely, it doesn't apply itself. On the first date itself, my lords, on the date, there is a non-bailable warrant issued. How is a non-bailable warrant issued, my lords, on the first day itself, where the police has made no effort to locate me or find me or done anything apart from that? First day. And the magistrate says that in Dawood Ibrahim's case, my lord, Supreme Court has said that I can issue at the stage of investigation. So therefore, I'm issuing. That is the only criteria, which is the issuance. And in the second time, when it comes from proclamation, he says, I have issued it based on Dawood Ibrahim, and therefore I'm issuing the proclamation. My lord, surely these, and the Supreme Court and your lordship's court has said, these are matters of serious nature because they attach a criminality to a person, my lords, issuance of a non-bailable warrant. And Dawood Ibrahim was a case where after filing of charge sheet, 167 remand came into play, and on that remand, my lords, it was a question of persons against whom charge sheets had not been filed, whether they could be arrested or they could not be arrested. Now, if your lordships think, I am only praying that as far as the investigation is concerned on the first, if your lordships are not inclined at this stage to interfere with and hear the matter finally on a particular date, but as far as revision is concerned for a person who was not in the house, whose house it is not, and based solely on the confessional statement of the brother-in-law, he has been implicated, and that confessional statement has been set out in extenso in the FIR itself, my lords. It is astounding how a confessional statement can be there in a FIR. Please see the FIR if your lordships have seen it, but please read with me, my lords, that part where he says.
So in that event, let me pass an order in 226 application.
In the writ petition, let the affidavit come, but there is another prayer. All my properties are.
Of course, after hearing the learned advocate response.
My lords, there is one as far as seizure of
because I will not mix up those two matters.
No, I'm not. In the writ, my lords, there is one subsidiary prayer which is there before your lordships, which is there that they are going on attaching all other properties of mine. They have enough material of mine with them, my lords, as is evident from the FIR itself, my lords. It's not some small amount which is there. Are going around attaching for the time being those coercive steps your lordships may consider. If they don't apply, my lords, these sections. Suppose your lordships come to a conclusion on the next date, and I'm able to persuade your lordships, my lords, that none of these sections are made out, and your lordships agrees with me and asks the state, my lords, this is not an offense under BNS. Seizure of money and gold is not an offense under BNS. Please report to the income tax authority. Then, my lords, all these attachments, my lords.
Yes.
That is the judgment of Supreme Court in Nevada, my lords, that I may place before your lordships. This.
Just see. And my sealing of my house cannot happen on the first day. My house, my para 9 of the para 9 of the
Now, please see, my lords, this.
Just a minute.
Sorry.
Just see this para and then show it.
This is your prayer.
No, this is what they have done on 30th July. 6. You cannot.
Para 9
Yes.
My lord, paragraph 31 and 32 of the second judgment, Nevada, my lords, which starts, my lords, at page 4. Page, my lords, I'll read from the scope of 102, which actually starts, my lords, from page 22.
Can I have the reference, please? Can I have the reference?
Oh, sorry. It's 2019-20 SEC 1.
Sir.
Sorry. Yes, sir.
এই এসিটাকে একটু বাড়াতে বলুন, শুনতে পাচ্ছেন এসিটাকে বাড়াও প্লিজ, ইজ নট ফিলিং কমফোর্টেবল প্লিজ। Yes, it starts from page 4.
Page 4.
Nevada judgment.
Yes, my lords. Para page 22, my lords.
Yes, page 22, paragraph
28, my lords. Para 27 is the conclusion. Lordships may have a glance, my lords. I apologize. Having held and elucidated on the power of the criminal court, we find good ground and reason to hold that the expression any property appearing in section 102 of the code would not include immovable property. We would elucidate and explain. The first part of subsection 1 of section 102 of the code relates to the property which may be alleged or suspected to have been stolen. Immovable property certainly cannot be stolen and cannot fall in this part. The second part relates to the property which may be found by a police officer under circumstances which create suspicion of the commission of the offence. We have already referred to the judgments of the Delhi High Court in P.K. Parmar, Swan Sabarwal and Jagdish Chandar, which have elucidated in a restricted and narrow manner defined the requirement for invoking the second part. However, we have come across a decision of this court in Teesta Setalwad on an appeal from the judgment of the Gujarat High Court and had dealt with the situation when an act of freezing the accounts was a sequel to the crime as the crime was detected earlier. The Gujarat High Court took a somewhat contrary view by not interfering and directing defreezing, observing that even if the action of the investigating agency at inception to seize may not be regular, the court cannot be oblivious to the collection of substantial material by the investigating agency which justifies its action under 102 of the code. Further, when the investigation had progressed to a material point, defreezing the bank accounts on the basis of such argument would paralyze the investigation, which would not be in interest of justice. After referring to the factual matrix in Teesta Setalwad, this court observed that the investigating officer was in possession of material pointing out the circumstances that had created suspicion of the commission of an offence, in particular that investigation and therefore exercise of power under 102 would be illegitimate as it was exercised after following the procedure prescribed in 2 and 3 of the same provision. 102 postulates seizure of property. Immovable property cannot in its strict sense be seized through documents of title, etc. relating to immovable property can be seized, taken into custody.
This is a case of defreezing of account.
Sorry.
This is a case of freezing of account.
In our case, my lords.
No, it's a case which you are
of my lords, freezing of attachment of properties, my lords.
Freezing of account.
And immovable.
Account was debit frozen, probably.
Sorry, my lords, it was.
So how does it relate to the present case when on seizure it is found that a huge amount of gold bars, silver and cash were recovered from cupboard?
This para 9, my lords, in my writ petition, para 9 in my writ petition deals with the immovable properties being seized.
No, but it has to be considered based on the facts of the present case.
It can't be.
Immovable property may have a wider connotation, but that does not mean that the freezing of bank account would be related to
not
the present facts of the case, where huge amount was gold bars, silvers, and cash were recovered from cupboard.
In that house, my lords, which is falling from your lordships, as a crime scene that can be sealed, my lords. My properties, which I have addressed in paragraph 9 of the writ petition, your lordship.
This matter, the facts of the case, so far this Nevada is concerned, is relating to freezing of account.
And that says you can't attach immovable, you can't seize immovable properties because immovable properties cannot be stolen, immovable properties can't be there. Kindly see para 29 and 33 and 34 specifically. Please see that, my lords. Para 32 specifically, I will not read the others. In case, at page 24. In case and if we allow the police officer to seize immovable property. Please see this. On mere suspicion of the commission of any offence. Sorry.
What of him? Who to that? Your house. But it talks about seizure of immovable property, attachment of immovable
Cannot
property.
be done.
But how? But in this case, the movable properties and the valuables were recovered.
No, but now they are, that's my prayer in the writ also, my lord. That's why I was pressing for the interim stay, since it fell, your lordships would hear it. If para 9 in my writ, they are attaching my residential house, they have attached my office buildings. All that can't be done in view of the Supreme Court judgment. You can seize whatever you want as far as immovables, because otherwise you will become the police officer, not you, my lord, sorry. The police officer will become an adjudicator, is what the Supreme Court says. So those properties have to be ousted. A residential building.
No, but the court is focused so far. The present case is concerned with regard to the seizure made on 29/30th.
But that is there. That is against.
But during course of investigation, if such attachments are made, then you have to approach the appropriate forum.
Your lordships is the forum. There is no other forum I can go to.
You can approach the jurisdiction magistrate.
Jurisdiction magistrate has no power. There is nothing before him. This is an administrative, this is an action by the police. Only your lordship's wide powers under constitution, my lords, under 226 can protect a citizen, my lords, between the guardian between the state action and excesses, my lords, and the citizen. However bad the citizen may be, my lords, but your lordship's powers are operate, my lords, without any looking at what search, seizure, that particular property, assuming, my lords, that's a scene of crime, are seized by them, but can't go on sealing all my immovable property, including my residential premises. Please see my prayer, my lords, in my writ, page 11.
Page 11, paragraph.
My lords, I'll just read, sorry.
Yes.
My lords, therefore, my lords, but relation to immovable, though aside, that's why the Honorable Supreme Court.
There is a case made out in the writ petition regarding
lords,
attachment.
paragraph 9 I have mentioned, my lords, page 11, para 9, my lords.
And prayer.
Slowly.
Page 9, paragraph 4.
No, page 11, paragraph 9, my lords. Sorry.
Very confident. Trying to
Yes.
My lords, specific prayer is prayer E,
70, page 71.
page 71, prayer E, my lords, if your lordships are pleased to turn to that. I have it.
71B.
Lordship, please. B and E. And E, my lords, specifically.
What is the fact of the case so far Nevada is concerned?
Nevada also, my lords, was a case where, pursuant to some disputes between the parties, the immovable property was being sealed. Pursuant to the disputes between parties, my lords. Page 4, if your lordships are pleased to see. I'll just show your lordships the. But Nevada is emphatic, my lords, on the power. It's a declaration of law by the Honorable Supreme Court, my lords. Once again, he wants the facts. Oh, my lords, I'm sorry. It was on a reference. It was a reference to a larger bench in view of the conflicting judgments, my lords, that your lordships will find at page 11 itself. But Honorable three-judge bench, my lords. A division bench of this court, video order 1811, noticing that the issues that
reading paragraph?
page 11, my lords, page 11.
Yes, page 11.
The first paragraph, my lords. Noticing that the issues that arise have far-reaching and serious consequences, had referred the aforesaid appeals to be heard by a bench of at least 3 judges after obtaining appropriate direction from the Honorable Chief Justice.
What was the reference?
My lords, the reference order is referred to, my lords, in just take out 2014 SCC online. And the specifically Nevada's case, my lords, is paragraph 2. For the sake of convenience, we have, while I take out the reference order, my lords, we have treated the criminal appeal arising out of specially filed by Nevada as the lead case. The appeal arises from judgment of High Court of Judicature of Bombay, wherein the majority judgment has held that the expression any property used in subsection 1 of section 102 of the Code of Criminal Procedure does not include immovable property, and consequently a police officer investigating a criminal case cannot take custody of and seize any immovable property which may be found under the circumstances which create suspicion of the commission of any offense. According to the majority judgment, earlier this decision of division bench of the same High Court lays down the correct ratio, and the contrary view expressed in Bombay Science does not lay down the correct view. The minority view holds that the police officer has power to seize the property, whether movable or immovable, under 102 of the code, and the decision of the High Court in Bombay Science and Research does lay down the correct law, and Singapore is not good law. And the reference.
This was the issue.
Yes, specifically. Bombay High Court had a larger bench also, and there was a majority and a minority. And then it came up, my lords, then there was a batch because these issues must have arisen across high courts, my lords, and therefore the matter was placed. वो judgment निकालो ना, reference वाला.
Reference निकालो.
Yeah. They use it. Yeah. That's a declaration. Correct.
Yes, so precisely.
My good friend from Delhi, my lord.
My dear friend, Mr. Bhattacharya.
He has made his overwhelming presence felt. Just that, my lord, we cannot have lunch or dinner together today since we are opposing each other, not appearing together. But the purpose is, my lord, of the petitioner to call out information regarding the development of the investigation. There are attempts, my lord, is operating from overseas. It's a very, very confidential report. My lord, may kindly, my lord, reseal it and hand it back, or my lord, keep it, my lord, in my lord's custody, my lord.
I don't know what the document is, my lords. I am on my writ petition and for quashing and these ancillary prayers for the time being. Tell him what? Let's see what there is. Stage of investigation. What you were doing? Yes. It is
4 July.
they are the
Yeah, 4th August.
full status report.
Nothing. This is the status report. 4th August is a joint task force. If you want to keep something which is across the body, we are disclosing everything. Disclose something on this. They claim secrecy in terms of official secrecy.
नहीं हो सकता can't ask.
You guys just to ensure that you don't get your eyes small issue of correcting. So, but it's making a dent. Yeah, making a dent. I understand strategy.
इसमें है ही नहीं ये तो दूसरा चिदम्बरम सील्ड कवर नहीं तो ट्रिपल टेस्ट है
29. अच्छा my house. Can you show it to me? This is as of today. Can this be done? Is it a sleeping station for police officer? Doesn't have house.
I agree.
There are reasons for incorporating section 111. It's an organized crime which is going on, as a result of which government is losing revenue. Stone mining is going on, and that this duplicate carbon receipts are being issued in order to obviate payment of.
Kindly, my lord, kindly not divulge, my lord. I would pray.
Because the envelope that has been handed over, my lords, is a practice that has been deprecated by the Supreme Court in the Chidambaram judgment. It is I am entitled to a status report by them in the.
So your points, Mr. Dave, is this that
Lords, by
first of all, based on seizure, this proceeding should not have been initiated.
Yes,
as you have stated.
Lordship.
As this point you have taken, and you are also you have complained of incorporation of section 111 of BNS.
Yes, and all
the
others.
requirement under as stipulated under section 111(1) II is not fulfilled.
Lordship.
This is the third point, and you have relied upon paragraph 32 of Nevada judgment.
Yes.
Yes.
And my lord,
no further, please. Yes. Yes. I have heard. Yes. Mr. Mitro, anything you want to add?
Yes, see, the investigation is, my lord, at the beginning, my lord, that is being carried on.
Magnitude of the crime.
And, my lord, your lordship has seen, my lord, the magnitude of the crime. Now, my lord, 111, my lord, it can be done, my lord. I can show your lordship, but
only thing that
yes,
where I am asking you, as Mr. Dave has taken this point, if you come to 111 and the definition as of
BNS.
continuing unlawful activity.
Yes.
Because if you consider, if you go through section 111 subsection 1,
Yes.
any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cybercrime, trafficking, so and so forth. Now, this will constitute organized crime. Now, while giving the definition which is offered under section 111 1II, continuous unlawful activity means an activity prohibited by law which is a cognizable offense punishable with imprisonment.
Yes.
Imprisonment of 3 years or more undertaken by any person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. So where is the fulfillment of these conditions? Taking note of the definition of continuing unlawful activity.
Yes. Now, well, two charge sheets have been filed, my lord, and court has taken cognizance of it. Reporte bola bodhai ami jai na.
Charge sheet has to be filed before invocation of 111, not after invocation of 111. That charge sheet is, I don't know what is being handed over, but if that is after 30th of July, then it doesn't fall within the ambit of 111.
167 charge is there referred in the FIR.
But these are the charge sheets after the initiation of, after registration of FIR.
I know it.
After filing of the writ.
I know it. I know it.
After filing of the writ.
After filing of the
ground, defeat the ground. Like
ऐसा हो रहा है वो देख में ये खराब है the same problem.
They quoted in the writ.
there is one charge sheet you have filed, that is 4th August 2026 in connection with this is final report charge sheet number 1979. In FIR number 220/2026, Police Station Mohammad Bazar 2026. This is one charge sheet. And where is another? Also 4th August 2026. In FIR number 216/26 dated 4th July 2026. These are the two charge sheets.
Lord, may I pray that your lordship's district.
But as it is being argued that before initiation of the proceedings, if there are preceding other charge sheets, more than one charge sheets as contemplated in the definition, anything is there?
Well, I have to take instruction, my lord. That's all.
Thursday. Give us a copy of the charge sheet.
What is your response to that? With regard to this fulfilling the conditions, in
Kindly
order to
come,
arm the alleged offense
Yes.
as an offense under section 111.
kindly come to my lord 111 once. My lord.
Yes, yes.
Any continuing unlawful activity, including it's including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cybercrime, trafficking of person, drugs, weapon or illicit goods or services, human trafficking for such and such, for by any person or a group of persons, acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat or violence, intimidation, coercion, or by any other unlawful means, to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Then, my lord, kindly explanation. Kindly come to, my lord, the two. Continuing unlawful activity means an activity prohibited by law which is cognizable offense punishable with imprisonment of 3 years or more, undertaken by any person, either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. And that court has taken cognizance of such offense and includes economic offense. Now, my lord, with respect, my lord, it does not say, my lord, when, my lord, this cognizance has to be taken. The offenses are, my lord,
I know.
now, my lord, in any event, as on date, assuming, my lord, it was not there, my lord, this section could have been added subsequently also.
This
111 could have been added subsequently also. Now,
after filing of this charge sheet.
yes, additional charge sheet could have been filed. So there is no difficulty.
But as on date, there are two charge sheets.
Yes. And, my lord, the investigation is going on, my lord. Several persons, my lord, have been apprehended, my lord. Possibly that would. Including, my lord, officials.
Because may I only pray But your lordships may
Yes,
consider
and
this.
sorry. And the gold bars,
They are all Swiss gold bars. This is the Hawala Nexus also.
Mr. Bhattacharya may know that you can buy Swiss gold bars in India in a shop also. It is not so that you have to go to Switzerland to buy Swiss gold bars, my lords. That's not the criteria. Now, this, my lords, on 111, I'm laying emphasis on 111, my lords. And
But Mr. Dave, only
I would
on
like to
this,
assist.
only on this point
My lords, I would like
of
to assist.
incorporation of section 111, whether it is rightly incorporated or not, I am not inclined to
Then may I-
frustrate the prosecution which has been initiated
My lords,
against the
I want to assist your lordships on this on 111. And on 111,
considering the magnanimity of alleged offense.
my lords, if it was so of such
Considering the magnitude of
if it
alleged
was of
offense.
such magnitude, my lords, as is thought to be made out, as if it threatens the sovereignty, integrity of India, as if it is of an offense of such a nature, my lords, that NIA is investigating, some terrorists are involved, it is not. I am not far removed from mining. I have been mining and I have licenses for mining. It is not that I am a person who does not hold licenses and I've been mining. I have placed those licenses on record before your lordship, my lords. I am involved in the profession of licensing, of mining, and I have licenses for that. Now, if I breach those licenses, I have mined more than what is I am authorized to. I have mined less. They are all under MMDRA Act, my lords. This can't be. But I would like to assist your lordships on 111 specifically, my lords. Today, my lords, I am only praying because this is borrowed from Maharashtra Control of Organized Crimes Act, my lords. West Bengal does not have such an act, my lords. As yet, it does not have it. That act has been extended to Delhi by the same title, Maharashtra Control of Organized Makoka, what is known as otherwise Makoka. And the language that is borrowed in 111, my lords, is almost identical from this. Today, I don't have the judgments for it, my lords. I would like sometimes next week, my lords, to come back and assist your lordships on 111 and this exact interpretation that I am submitting before your lordship. If your lordships give me the chance, the judgments of MCOCA, my lords, apply identical to the provision as far as this 111 is concerned. And the criteria is to not only filing of charge sheet, it's not enough. A magistrate or court should have taken cognizance, my lords. That is the second. After having wrongfully invoked it, can't say I can add it any point in time. Because after all, they are police. They are subject to some rules and regulations. My lords. It can't be that I'm running riot and doing whatever they feel like. That is why, your lordship, I would like to assist your lordships, my lords, if your lordships permit, on 111 and come back and show the judgment which is identical on that. And as of today, I have police officers.
Today I will close the matter so far 2022.
My lords, I have police officers sitting in my house. They made it into a police station as far as this is concerned. I have photographs.
There are confessions before the police officials that these are the wealth and these materials are materials belong to whom?
My lords, your lordships.
There are confessions. So at this stage, at this initial stage, whether it would be
Attempts, my lord,
My lords, if you're
with the witnesses and the evidence, my lord.
My lords, if the best evidence that they have is of confessions, my lords, that means the police is the weakest investigation. Confession of a co-accused which won't even stand to trial. Confession of an accused which does not inadmissible in evidence is the best evidence that the police has of today, my lords. Your lordship's court will not countenance for the police. If it is admissible under a particular act, I can understand a statement, especially under ED, PMLA, some statement is admissible because of Vijay Madanla. But today, my lords, is what has been handed over to your lordships in a sealed cover, which I am not privy to, they don't want to disclose. But to say that this is of wide magnitude, my lords, and there are confessions that are there of co-accused persons, their confession, their FIR starts with confession. Please see the confession in itself. And what is a confession?
No, at this stage, whether court is not required to enter.
But court will require, my lord, to see the material objectively. They are only placing, my lords, in a sealed cover before your lordships. The material that is there, which I don't know, if I had been shown, any criminal lawyer, my lords, worth his salt would have said this confession is not worth the paper it is written on. It is not the accused who writes it, unless it's a magistrate confession under 164. At this stage or any stage, unless it's a confession made under 164, my lords, it is not worth the paper it is written on. And therefore, my lords, your lordships may not countenance that as far as giving this picture that is of wide magnitude. My lords, if today the police changes or something changes, these very persons who implicate this will implicate someone else. That's why even the British people didn't realize that 25 and 25 is retained in BNSS. For some reason, my lords, there is a reason why it is there. And that is the best evidence. Please allow me on 111, my lords, and to place some judgment before your lordships, my lords, that even certain provisions at the time of challenge can be quashed by your lordships at the 226 stage. It is not, if it is not made out, it will be quashed. It can be quashed qua a particular person also. Partial quashing is now permitted, my lords, as far as FIRs are concerned. So I'm only praying, my lords, your lordships may hold it over if your lordship is not inconvenient. I will address on 111 because 111 is the most drastic of the provisions that has been invoked by them.
By presenting this writ petition, comma, inter alia, comma, petitioner has questioned, petitioner has questioned propriety of FIR being FIR number 267 of 2026 dated 30th July 2026. Being Mohammad Bazar Police Station, being Mohammad Bazar Police Station case number 267 of 2026 dated 30th July 2026. Stop. Mr. Dave, learned senior advocate representing petition. Submits that based on seizure conducted by based on seizure, yes,
the same point, we are co-accused person, it become
based on seizure, based on seizure based on seizure which was conducted on 28 July 2026. Aforesaid FIR was drawn up and criminal prosecution was initiated. Which is impermissible, and there is no complaint lodged against the petitioner. So, it is also contended. It is also contended on behalf of petitioner that FIR's impugned FIR reveals incorporation of section 111 of Bharatiya Nyaya Samhita 2023, though conditions contemplated under section 111 of BNS 2023 are not fulfilled, which would enable concerned police authority to fasten section 111. Stop. Notice of this court has been drawn to section 111 and definition of continuing unlawful activity, quote unquote, attributed under section 111 within bracket 1 within bracket II. Stop. According to petitioner, in order to attract section 111 in connection with the criminal prosecution, there has to be more than one charge sheets. There has to be more filing of more than one charge sheets before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offence. Mr. Dave, only one thing.
Yes, Malad.
While dictating the order, please come to section 111, 1II.
1II, Malad. Economic offence.
Just a minute, you need not read in its entirety. Under II, it says either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charges have been filed before a competent court within the preceding period of 10 years.
Yes.
Within the preceding period of 10 years.
Yes.
And that court has taken cognizance of such offence, comma.
Yes, Malad.
And includes economic offence.
Yes. Yes.
So whether this economic offence
Yes.
is kept
Separate.
outside the purview of continuity of unlawful act?
Yes. So
because there are several
Yes.
heads or several terms
Yes, Malad.
which are indicated in section 111.
Yes, Malad.
Any continuing unlawful activity including kidnapping,
Yes.
robbery,
So those are
vehicle
separate.
theft, extortion, land grabbing, contract killing, economic offence.
Yes, Malad.
Then cyber crimes, trafficking of persons, drugs, so and so forth. But while defining continuous unlawful activity,
Yes,
this economic offence
Yes, Malad.
Was kept outside, as it appears that it is kept outside
Yes.
the definition which is attributed to continuing unlawful activity.
Milods.
And economic offence.
And so economic offences are defined, Milods, in 3.
Comma and includes economic offence.
And which are defined, Milods? Which are defined. Economic offences are also defined.
Which of trust, forgery, counterfeiting of currency, in any form. So therefore, economic offence is not coming within this definition of continuing unlawful activity.
So that,
and there is an economic offence. If you come to economic offence as defined under section 111,
yes,
1II, economic offence includes criminal breach of trust, forgery.
Yes.
But there, the requirement of filing 2 charge sheets within a preceding period of 10 years, that is absent.
No, Miloj. With respect.
That is absent, Mr. Dave.
With respect, Miloj. The requirement is of an
because a separate meaning or separate connotation is attributed so far economic offence is concerned.
Just for a moment, if your lordship sees II, the requirement is of an offence which is punishable by more than 3 years. That's the opening line. That's the first part of II. Means an activity prohibited by law which is cognizable, punishable with imprisonment of 3 years or more. First requirement. Then it comes undertaken by any.
But that does not include economic offence.
No,
as it appears, because that's why and includes economic offence.
Preceding 10 years, and that court has taken cognizance of such offence and includes economic offence.
First comma, they and includes economic offence.
For what, my lords? For the offence.
Then economic offence is defined separately.
So for the offence.
So therefore, the conditions which you are arguing that there has to be 2 charge sheets and filing of those charges before the competent court within the preceding period of 10 years, whether that will apply in case of economic offence.
And that has been held, my lords, by the Supreme Court in MCOCA cases, which are identical. I have taken out the bare act, my lords. I'll just show to your lordships in this. MCOCA also has the same provision, which is there about this, which has been interpreted by the Supreme Court, because this is an older act. It's from 1992 in Maharashtra. Now there also, my lords, if continuing unlawful activity and organized crimes, etc., are all defined. No, they won't have it here. It's not used here. They are all there. But on the interpretation of that, when your lordships reads that offence organized on behalf of such syndicate in respect of which one or more charge sheets have been filed before a competent court within the preceding period, and that court has taken cognizance of such offence and includes economic offence. The word economic offence relates to this offence. In the last line, my lords, in my respectful submission, the cognizance of such offence is and includes.
But if you compare it, II and organized crime under subsection 1,
yes,
there are different terms or different.
Yes, no doubt.
Various offences have been described.
No doubt.
Activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offence, cyber
economic offence.
Out of which this economic offence has been stipulated separately under II.
True, my lords. Your lordship is right. But economic offence then forms part of the main definition of unlawful continuing activity also, my lords, there.
কি বলছিলাম? Stop. সেন্টেন্সটা কিভাবে শুরু করেছিলাম? Stop. Stop. In the present case, such ingredients, in the present case, such conditions are absent as contemplated under section 111 within bracket 1 within bracket II. And as such, incorporation of section 111 is bad. And is bad and impermissible. Stop. Next paragraph, reliance is also placed on judgment of the Honorable Supreme Court reported in 2019-20 SCC 119. Within bracket Nevada Properties Private Limited to its directors versus State of Maharashtra and another. In order to contend that on the strength of section 106 BNSS 2023, immovable properties, lands, plots, residential houses cannot be seized in connection with the criminal prosecution. However, it is also submitted that in in the present criminal prosecution, immovable properties as described in paragraph 9 of the writ petition are being seized. Which supports the case made out in the writ petition that the prosecution is not directed towards criminal prosecution is not taken towards right direction, requiring interdiction by this court in entertaining the present writ petition under Article 226 of the Constitution of India. Next paragraph, during course of argument, Mr. Mitro Learned, Advocate General representing state respondents, in a sealed cover, has filed a report of Inspector in Charge, Muhammad Bazar Police Station, dated 20 August 2026, which wherefrom it transpires that due to alleged acts and actions of the petitioner, state government is losing. State government is incurring huge revenue loss, which are connected to stone mining. Stop. It is also disclosed in this report dated 20 August 2026 that from these documents, in connection with impugned criminal prosecution, it has been found that there are malpractices regarding preparation and issuance of duplicate carbon receipts within bracket DCR. Stop. However, at this stage, court is not inclined to narrate alleged acts and actions of the petition, which is subject matter of investigation in connection with Mohammad Bazar Police Station, case number 267 of 2026, dated 30 July 2026. The report dated 20 August 2026 shall be kept in sealed cover with the present record. Next paragraph. While opposing the case made out by the petitioner, it is contended on behalf of state respondents that there are two charge sheets filed one being charge sheet number 196/26 dated 4th August 2026, in connection with Mohammad Bazar Police Station FIR number 216 of 2026 dated 4th July 2026, and another is charge sheet number 197/26 dated 4th August 2026 in connection with Mohammad Bazar Police Station FIR number 220 of 2026 dated 6 July 2026. According to the state respondents, while determining the issue whether in the impugned criminal prosecution Section 111 of BNS 2023 needs to be incorporated or not, these two charge sheets ought to be taken into consideration. Next paragraph. Having considered the respective submissions made on behalf of the parties and the case made out in the present writ petition, this court finds it apt to consider the exercise made by police authority on 28 July 2026 and seized cash, gold bars and other items from cupboard of from cupboard kept at the residence of one Minar Mondol. Stop. Teaser list prepared on 20 July 2026. Discloses a recovery of gold bars, and huge amount of cash. Stop. Properties, movable and immovable, suspected to be proceeds of crime, are have been found. And based on recoveries, investigation is going on. Stop. Investigation is at the nascent stage. Therefore, at this stage of criminal proceeding, court finds it improper to make an endeavor to find out the veracity of allegations. Veracity of allegations. Stop. Next paragraph. The issue which requires consideration is incorporation of section 111 in the impugned criminal prosecution. Stop. For better understanding of section 111, for better understanding of the term organized crime, enshrined under section 111 of BNS 2023. Section said provision is quoted. Section 111 take a set out. Stop. It was contended, it was argued on behalf of petitioner that in order to attract 111 section provisions under section 111. Conditions defined under the definition of continuing unlawful activity, quote unquote, are required to be fulfilled, comma. Those conditions are against a member of organized crime syndicate or on behalf of such syndicate, more than one charge sheets whether filed or not before the competent court within a preceding period of 10 years. Stop. That's it. It appears that two charge sheets, as alluded above, both dated 4th August 2026, were filed in connection with other FIRs. Stop. Moreover, while defining continuing unlawful activity, quote unquote, economic offense was treated separately. And separate separate definition is given under section 100 in section 111 within bracket 1 within bracket III triple I. So far economic offense is concerned, economic offense is quote unquote. In the present case, apart from section 111, other sections are sections 308/316 within bracket 2, 316 within bracket 5, 317 within bracket 4, 317 within bracket 5, and 318 within bracket 3. Stop. Taking nature, considering nature of allegations made against the petitioner in connection with the impugned FIR. And there are 2 charge sheets filed, both dated 4th August 20, and there are 2 aforesaid charge sheets filed in 2 other separate criminal prosecutions. Court is not inclined to interfere with the decision of respondent authorities to incorporate section 111 PNS 2023. Stop. Concerned police authorities are directed to investigate the case in accordance with law. The petitioner has an alternative remedy under section 482 BNSS 2023 by moving pre-arrest bail application before appropriate forum. Stop. Reliance is placed on the judgment of the Honorable Supreme Court reported in 2021-19 SSC 401, Niharika Infrastructure Private Limited versus State of Maharashtra and others. Stop. Paragraph 33.16 runs infra. 33.16 term set out. Next paragraph. Before parting with, it needs to be recorded here that it is admitted in the writ petition that petitioner has left this country on 23rd May 2026. Which does not instill confidence in the mind of this court. Stop. Niharika Infrastructure. Next paragraph. এই সেন্টেন্স এই প্যারাগ্রাফটা দেবার আগে ওই নিহারিকা ইনফ্রাস্ট্রাকচারের শেষে একটা বলবে নিহারিকাটাকে কোট করার পরে বলবে রিট কোর্ট while exercising jurisdiction under Article 226 of the Constitution of India, considering a petition seeking quashment of criminal prosecution, needs to exercise such power with circumspection and sparing, comma, it is not a routine procedure that on an application seeking quashment of criminal prosecution, same shall be dealt with mechanically, thereby directing the concerned police authority not to take coercive steps, especially when allegations are grave in nature and a report is filed before this court dated 20 August 2026 by Inspector in Charge, Mohammad Bazar Police Station, Birbhum, disclosing alleged conduct, disclosing alleged actions of the petitioner. Hence, present writ petition is dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law, if so advised.
By revision, revision will have to be heard now since your lordships have dismissed.
Revisional application appear on a subsequent date. You can appear online. No issue. You can appear online, Mr. Dave.
Just pointing out.
Yes, yes. That will be considered separately. All matters cannot be clubbed together in this fashion, Mr. Banerjee. This was mentioned by Mr. Rohatgi. I have fixed this matter. I have decided this matter. So for revisional application, it has been assigned to me. I will hear it on a subsequent, on a particular date. And Mr. Dave, you will appear online.
I can
If
come.
it is difficult for you,
I can come Thursday, my lord. Thursday is a holiday in Supreme Court. I can come here next Thursday, which is 27th.
Holiday.
We are. There's no holiday here, but no. Your lordships are closed on 26th.
26 probably. Till date, our calendar, there is no indication, but since there might be some confusions with regard to sighting of moons and other things. So that's why Muslim festivals holidays are declared at the 11th hour.
But this is Miladul Nabi. It has nothing to do with moon. I think it's the Prophet's birthday, my lord. It's not.
So when do you want? On
27th, if it's not
27th,
inconvenient.
if it is not holiday, then 27th.
27th. I can come physically because we are closed then.
একটা separate order করো relating to the civil division. Yes. Yes.
Can it be on 28th?
28th is Raksha Bandhan.
Come down and stay back on Saturday. We'll have lunch.
I have two sisters, my lords. I dare not step out. That's the only time I stay there.
On Rakhi,
Rakhi, I'm not allowed to move out of Delhi, my lords.
27th, please.
27th, right? The Advocate General can.
Mr.
I'll tell you,
Mr. Advocate General, adjust your other matters and appear in this matter.
Before the Honorable Chief Justice's bench, my lord, regarding this Badwipur incident.
Which incident?
The Badwipur incident.
Yesterday only it was fixed.
Can have it at 2 o'clock if it's not. If it's not inconvenient, we can.
So
have
you
it
discuss accordingly and tell me.
Sir, can we have it at 2 o'clock?
In every aspect, court is not required to decide.
Fine.
Yes.
Kindly keep it at 2, my lord. We shall, my lord, try to.
With revisional application, give me that revisional application.
It's 3444 of 20.
Item 4. Just a minute. ওইটা নিয়ে
Meeting is item number 4 in my list.
criminal divisional application being 3444 of 2026 is also heard today. Hearing of this revisional application is adjourned. List the matter for further consideration on Thursday.
27.
On Thursday next, 27th August 2026, as 2 p.m. fixed matter.
I'm grateful, my lord.
Record, my lord, that we have received a copy, my lord. They have served a copy of
Yes, thank you. Nobody is
the
denying.
revision application.
I thought my dear friend
Very
would
well.
trust me.
During course of hearing,
I tell
add another line. During course of
My
hearing,
dear friend doesn't
copy of
trust
the
me.
revisional application is made over to the learned advocate representing state respondents.
Grateful. Grateful, my lord, for the patience.
55 will be taken up, I request to keep 55.
Arising out of same
Item number 6.
এইটা দুটোর সময় কি ফিক্স করা আছে? হ্যাঁ? আচ্ছা, হ্যাঁ, মনে পড়েছে। Yes, who is appearing for the petitioner?
I'm for the respondent number 6, SDFC Bank.
Where is Mr. Mohit Mukherjee?
Here only. Because here only Barasi thought that Millard will not return before his.
Well, not today. Not today. Members of bar may have thought that after 2 p.m. matters no.
Item number 7.
My lord, I beg to appear.
mentioning, my lord, but my lord kindly appreciates earlier item number 7. My lord, your lordship was kind enough to fix the matter on 3rd. My lord, 3rd, I have some personal difficulty. Can it be taken on 8th, 11th? My lord,
I'm for the state.
state, my lord. Petitioner, my lord, I shall inform him, my lord. But he just went away after the matter was called on. But I believe, my lord, he will not raise any objection. My lord, I inform করেছো তুমি? I said that it will be mentioned for only shifting of the date, my lord.
10 September.
10th, my lord.
10 September inform.
I shall inform, my lord. I shall inform, my lord. Grateful, my
এই
lord.
ওটা বলে দেবে তো ওটা যাতে সঠিকভাবে 10 সেপ্টেম্বর
Grateful, my lord.
No, you are going on deferring the program. Twice you have deferred as you mentioned, as you have informed this court during mentioning. Now, if it is being deferred, then where is the urgency? You are keeping, you are continuously deferring it, then there is no such urgency. Then, so there is no strict date which is to be observed. There should not be any date which should be observed. You have deferred once. You have deferred once. So if you have deferred once, then let it be. Yes. So then why you have deferred? You could have moved the court previously. On this plea, several matters are being taken up out of turn. If you keep on deferring the program and you will come before this court on the ground of major urgency, the court will not consider it. Let it appear as per presentation form in the list, and then you mention. Let me see. No, you will defer it again. You will defer it again. What can be done? Once you have deferred it. No. Sorry. Please call the list. Yeah, let it come.
Item number 5.
Item number 7. I appeared for the state.
No.
I am appearing for the item number 7. I missed it before the rising of the lordship. Item number 7, I am appearing for the state.
Item number
7.
Yes.
I am appearing for state.
State. So you did not appear at a time when the matter was called on.
I was on the way by that time, lordship.
So what can be done? Appear, then it will consider. Yes.
Then lordship speaks.
Then I have to allow similar prayers of all the learned advocates representing petitioner and state. No, there is no special treatment. So state is concerned.
I am not seeking any.
Please call the list.
Kindly not.
Item number 5.
Adverse order. That is.
Please call the list.
Lordship. Item number 5.
Lordship, I am up here.
When your program is fixed, schedule today, and today you are asking this court to hear this matter.
They have said that.
Sorry, no, not at all. Not at all. Sorry, I have refused your prayer. If it is scheduled today, it's not possible. Sorry, there are matters in the list. I have taken up one urgent matters in the morning. Entire morning has gone. Sorry. Please don't interrupt court proceedings. Please don't interrupt court proceedings in this fashion. You ought to have come earlier. Yes. What is
Yes, sir, Lordship. Sir, my affidavit of service. Sir, 2 affidavit of service, sir. Earlier one and the latest in August. There are 2 affidavit of service, sir. Earlier I had done in April and now in August, 17th August.
You are appearing in this matter?
Lordship, I am for the respondent number 7, the bank.
Yes, what is the matter about?
So this is a claim for a false case they had done upon me in 2000.
Now you are agreed by the damage which is caused to your car.
Right, sir.
Now what police will do?
So
what police will do?
No, it's not a question of police. There's nothing to do. I have just claimed, according to the Supreme Court law, section 406 and 4020 do not lie together.
Regarding
And
damage.
Yes,
So what police will do?
So there's nothing.
I have a determination to take up police matter.
I agree, but I took a permission from the Justice Mantha, where the coordinate bench had taken the case for 4 years for contempt and writ petition, and he had given me liberty to file again fresh.
That I do not know. Having seen the prayer, I do not find anything is required to be done by the police authority. You have prayed a direction upon the bank authority to supply certain documents,
right?
And then you have claimed damages for damage caused to your car.
Right.
Then what police will do?
So the police are involved in it. That is why the case started. The police are involved in it against. They are. The bank is involving the police to disturb me.
What manner?
So false cases.
What
false cases? Closing my chamber, not letting the patients come to my chamber.
What false cases?
Whatever they want, sir. If I sit in the chamber, they'll
omnibus submission will
no
not
omnibus. It's all written.
You have
sir.
to pinpoint the issues.
So if you come,
Otherwise, court will not
so
be
if
able
you
to
come to
appreciate your
annexure
case.
page 151, sir. If you come to page 151, sir.
No, your prayer does not indicate that any grievance is ventilated so far police authorities are concerned.
So the police authorities are involved in everything, sir. In false cases, the police authority. That's why the Supreme Court has said that 3 judges of the Supreme
Judgments will come later. First facts of the case, you have to satisfy the query of this court that this matter may be heard by a bench having determination to take up Group 9 matters, but not by a bench which is having determination to take up police matters.
So now the compensation comes into the writ petition also in Article 226. That is what Justice Bindal, that's why you have attached those papers. And if you come to 151, sir.
Where is the complaint before the police?
Pardon?
Where is the complaint before the police?
There are continuous complaints against the police, sir.
Where is the complaint in the writ
I'll show you.
petition so far your grievance is concerned?
So I'll just show this, sir.
You are representing whom?
The bank, respondent number 7.
So I'll just show that. So if we come to page 56, sir. The bank and the authorized, whatever they have, I have no loan, any claim to them. They still are trying to do. They are one of
your complaint to the police. This is not a complaint to police. It is Standard Chartered Bank's long history of financial crime.
Right.
But where is your complaint to police? That there is overt action of the police or there is inaction of the police?
So if you come to page 120, sir. Pardon? Oh, you want a copy? I'll give.
This is a complaint of 11th of March 2020.
That continued, sir. That continued.
Sure.
That continued.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner appears in person and presents his case. Petitioner appears in person and submits that necessary directions are required to be given upon the concerned police authorities to take steps. Bank authority, you are representing which respondent?
Respondent number 7, Standard Chartered Bank.
Respondent number 7 is represented by learned advocate. However, on perusing the prayers couched in the writ petition, it appears that petitioner has prayed for certain documents, supply of certain documents by the bank authorities, and also has prayed for payment of damages due to and has also paid for payment due to damage caused to card of the petitioner. However, in answer to the query of this court, whether any complaint is lodged before the police authorities ventilating grievance, a document which is at page 121 of the writ petition, a document is shown. না one part কেটে দাও pagination টা ঠিক নেই. A document is shown dated 11th March 2020 addressed to Hare Street Police Station. Stop. Based on a letter dated 11th March 2020, it transpires that writ petition is filed on 26 November 2025. Seeking direction upon the based on a complaint after based on a
So the complaint was 9/2/22, sir. And then the writ petition was filed.
Yeah. After preferring such representation dated 11 March 2020, writ petition was filed on 26 November 2025, after a period precisely after a period of 5 years, seeking direction upon the bank authorities to supply documents and claiming compensation for damage caused to the car of the petitioner. Next paragraph. Police authority, it is not demonstrated before this court that what are the steps which are required to be taken by the concerned police authorities. Stop. Next paragraph. Hence, present writ petition is not entertained and same stands dismissed. However, dismissed. Parties to act on the server copy.
Sir, can you give me a liberty to file again?
No.
Much on.
Item number 8.
My lord, service is not effective. I'm praying for not this one.
Number 7 হলো
5-7 হয়ে গেছে. You are appearing in 7. I don't know ওনার নামটা দিয়ে দেন. State is represented in 7 and that is recorded in my order. You are appearing for petitioner.
Yes, my lord.
Then why have you stated that matter is to be moved on 20th August? You could have taken 2 weeks more time. Issue. At the time of call, accommodation is paid for on behalf of petitioner since service upon the respondents is not complete. Next paragraph. Hearing of this matter stands adjourned. Next paragraph. Land advocate for the petitioner is directed to complete service of notice upon all the respondents by 10 days from date and file affidavit of service on the next date. List the matter under the heading motion non-service in the monthly combined list of September 2026.
Item number 9.
I am for the petitioner, my lord.
I'm for the state inspector.
My lord, here, my lord, the case was, my lord, the petitioner had filed a complaint of domestic violence. The husband is a civic volunteer of the local police station. No action was being taken. Milord was pleased to grant an opportunity to the state to come up with a report, Milord, for 7 days. Thereafter, Milord, what happened, Milord? There was a verbal direction also that the police officers will visit me and take all necessary steps. That was not done. I was called to the far distance, Fari from there is a Fari, Milord, attached to the পেজটা বার করে দাও। Page of FIR.
Whether any FIR is registered, Lordship.
FIR
is registered,
But I only have to show one thing from the FIR. I have prepared a supplementary if I am allowed.
Served also. This is a report, Lordship. Take steps.
Yes, one thing only I will show, Milord. Then whatever Milord decides, Milord, I will not stand in the way. Milord has been. রাহুলের নাম রাহুল ওকে বলেছি আসতে কি বলবো দেবে নাকি একটা কপি
Copy page.
আমরা হোয়াটসঅ্যাপে দিয়েছি প্রথম আপলোড করেনি কেন আপলোড করেছি আমার গুলো কোথায় প্রশ্নটা
Thirty-five three notices also.
Only one thing I wanted to show Milord, if Milord allows me to file a supplementary affidavit, just 2 page, and that's all, Milord. I will not show anything else. But Milord will, after seeing that, if Milord feels it is not required, I will take it back. Just for my satisfaction. Just for my satisfaction. Milord will kindly take page 19 of the supplementary affidavit. This is the first page of the complaint, which was primarily sent to me, Milord. This is a complaint which was received by the police officers on 30th of March. My Lord will kindly see it says received on 6th August. 6th August. But it was actually received on 30th of March.
Yes.
Milord, that is one point, Milord. And second point, Milord, will kindly come to the next page.
But does it whether it is important at this stage?
Only
when FIR is registered based on
why I am
complaint dated 6, how it will help you?
Milord, why I am placing, Milord, let me place page 20 and then, Milord, I will answer, Milord. Milord, in page 20, Milord. Page 20. Page 20, page 21 bottom, Milord, I am
21.
21 bottom. It is, Milord, may I please?
Just in.
Yes.
Yes.
So one point is that I do not feel that the investigation will be done properly with the police station. That is one point. And second point is, my lord, it is a technical.
It's too early to draw.
No, the second point is more important, my lord. Technically, my lord, what has been done is the FIRs that will be detrimental to me, my lord, in the time of trial. My lord, let it be recorded that I had complained on 30th. They have recorded after the order was passed. This much may be recorded, my lord. This much may be the observation of the court. Factually, this much may be the observation of the court, so that I am protected at the trial stage.
Filed 30th March.
30th March, I had filed the complaint. They say they have received it on 6th of August, which is not true.
In terms of order dated 6th August 2026, matter is taken up for consideration when learned advocate representing the state respondents has filed a communication dated 10th August 2026 of Inspector in Charge, Srirampur Police Station, and same is taken on record. Copy of the said communication dated 10th August 2026 is made over to learned advocate representing petitioner. Stop. Give a copy to him.
I have already.
Next paragraph, it is disclosed in the communication dated 10th August 2026 that based on complaint dated 6th August 2026, FIR was registered being Srirampur PS case number 447/26 dated 6th August 2026 under certain provisions of BNS, and criminal prosecution has commenced. And investigation has commenced. Investigation has commenced. It is also disclosed that notice under section 35(3) BNSS was issued to accused persons, and accused persons which was complied with, and another notice was issued to the complainant under section 94 BNSS 2024 or under section 94 BNSS. Stop. However, Mr. Nag, learned advocate representing petitioner, disputes contents of communication dated 10th August 2026 to the extent that though it is stated on based on complaint dated 6th August 2026, FIR was registered, but fact remains petitioner lodged complaint on 30th March 2026, and copy of said complaint dated 30th March 2026 is annexed at page 19.
Let it be page 74 of the writ petition. Because there the receipt by the police is there at page 74.
That I've seen at the top right hand side. Police endorsement made by the police officer.
Yes, yes, that's it. Page 74 is there.
A copy of the said complaint is annexed at page 74 of the writ petition, containing receipt acknowledged by Srirampur Police Station on the same date, that is 30th March 2026. Next time, in view of initiation of criminal prosecution based on aforesaid FIR, at this stage no further order need be passed. 7, except directing the concerned police authorities to expedite the investigation and take the same to its logical conclusion by submitting a report before the jurisdictional magistrate.
Obliged.
Petitioner shall also be at liberty to approach jurisdictional magistrate in the event occasions so arises. If occasions in the event if occasions so arises.
Obliged.
parties to act on server complaint.
Obliged.
Item number 10.
I appear for the state. Sir, I'm led by Mr. Mojumdar. He's on legs, my lord. I'll.
Who?
Mr. Razi Mojumdar, my lord.
It's the innocuous prayer, madam. I don't think Mr. Mojumdar's presence would be required so much. Madam, the petitioner is a youth president of Tamil Daho area, and his youth president of AITMC,
Youth president.
and his daughter-in-law is a member of Canning 2 Panchayat Samiti. Now, my lord, on a single day on 25/2026, my lord, 5 cases were registered, all alleging incident of 2020.
When it was registered?
20th May 2026, post regime change. 5 FIRs registered, all of 2020 by separate persons alleging similar incident. Exactly.
Alleging?
Similar incident. They went, they have taken cows and
What is your prayer?
now all those 5 cases I am finally on bail. Now what I beseech is a disclosure of case. That
They have
I
been uploaded.
The number of proceedings pending against the
Yes, we
No,
do that, my lord. They've been uploaded on the.
those uploaded is the FIR which I have mentioned. Whatever cases pending against me cannot be uploaded. That have
Well,
to
the
be
Superintendent of Police, Baripur Police District, be directed being responsible.
Man, we have made DIG law party as you know.
Deputy Inspector General, Inspector General Legal, Deputy Inspector General Legal West Bengal.
Yes.
Respondent number, yes, 3.
Well, in the writ, what they are seeking is a prayer against future FIRs.
No, I am seeking disclosure of cases.
Apprehends that there might be certain other criminal prosecutions pending against him.
Right, my lord.
It may be right, may be wrong.
Right, my lord.
So let a communication be made to the petitioner disclosing number of prosecutions as on date pending against the petitioner.
Very well, my lord.
Innocuous.
That can be done.
Where is your senior?
He is before courtroom number 1, my lord.
Yes. Matter is heard in presence of learned affidavit of service. Affidavit of service filed on behalf of petitioner is taken on record. Stop. At the threshold, it is submitted on behalf of petitioner that there are 5 criminal prosecutions which are known to the petitioner, in connection with which petitioner has obtained bail. Petitioner has obtained pre-arrest bail.
No, arrested bail.
Charge sheeted and now.
I surrendered and then got bail.
Petitioner has obtained bail. Stop. Surrendered and then obtained bail. Petitioner has obtained bail. Next. Stop. However, petitioner apprehends other criminal prosecutions may be pending against him, and prayer is made for directing concerned police authority to intimate if other criminal prosecutions are pending. Stop. State respondents are represented by learned advocate. Next paragraph. Taking note of the prayer made on behalf of petitioner, Director General and Inspector General. It is Deputy Inspector General.
Deputy Inspector General. Now I have confirmed because I have finally I have received one disclosure.
The Deputy Inspector General of Police within bracket Law West Bengal.
Right, madam. Now
Is
it is
directed to intimate the petitioner is directed to inform the petitioner by forwarding a letter disclosing disclosing the কেটে দাও কি বললাম সেন্টেন্সটা by forwarding a letter criminal prosecutions which are pending against the petitioner as on date by 7 days from date. Stop. Writ petition stands disposed of. Leave is granted to the learned advocate for the petitioner to amend the cause title and describe respondent number 3 appropriately. Stop.
Item number 11.
I have got the petition on my. There is a private respondent. I have already served.
I am appearing for the private.
Yes, who is for the petitioner?
I am for the petition.
Yes. You are for the state.
I am for the state.
There is private respondent also. I have served, madam.
Yes.
I am appearing for the private.
The petitioner is the widow. He belong the property with from his husband. I am staying with my daughter, two daughter. My property.
You have prayed for registration of FIR and conducting investigation in accordance with
I
law.
have a report.
Already registered FIR.
Lordship, FIR Lordship sees the complaints which he
So
wanted.
then it is not required.
It is because
Keep it with you.
because it is all there is an attempt to assault, attempts to break
Very
up.
well. If
Therefore, Lordship,
your complaint
as
is,
such, there is
if
no
no register, if FIR is
no
not
compensable
registered,
offences.
then High Court is not the appropriate forum. You have to approach jurisdictional magistrate under section
That
175.
is pending. That is there.
163 already.
That is-
I have
that is
given
done.
executive magistrate. There also report
That
also
is-
called for.
yes.
There is a threat being a panchayat member, as well also one of the police officer also went with. It is a admitted fact that the property is mine. Being a widow, they wanted to grab
Here
my
you have
property.
made out a case that there is a threat.
Police went full.
Yes, several complaints. 19/1/2026 from the 19/1/2026.
Lordship sees the report. The police lady constable was sent for the inquiry in connection with that case. That she did go.
My lord,
For the inquiry.
I made complaint to the commissioner. There also a complaint against also on one of the police officer who also said along with this
What
property,
was the last
who
order
has
passed?
no connection with this property. Why? For what reason they wanted to grab my property? That is unknown. This is property. Admittedly, property is mine, inherited from my husband, and western portion of the property they wanted to grab. But what purpose? He has no connection with this property. Who has no connection with the property, who has no right title over the property. This is that.
There
This
is
is
your
not to
complaint
prove that.
where court is not concerned with your right over the property.
Yes, my lord.
Because it's a police inaction matter, you have to address the
Police
court
atrocities
on a proper on the proper
police has
point. So what steps police is required to
Police
take?
is required to protect my property so that I have not been dispossessed at least. Because my property is trying to
If
grab.
if somebody is trying to dispossess you, then you have to approach the civil court.
No, my lord, who has no connection with, who has no right title interest.
Suppose a trespasser is there.
Yes, my lord.
On your property.
Yes, my lord.
Now, if this trespasser is present on your property, then for evicting trespasser, you have to approach the.
This is not
you
eviction.
have to follow the due process of
When
law.
the eviction was, when the property was grabbed, that time eviction was come. But he has a threat.
Come to the prayer. Prayer of your writ petition.
Till that encroachment has to be made. Thereafter, I come to go to civil court. I made complaint before the commissioner.
Prayer.
Prayer. Several complaint has made.
Round the clock.
Because if there is a complaint against police officer, obviously police has not given any report against in favor of him. Where police also accompanied with that person who was the member of the property panchayat. Being a political power enforcing, he wanted to grab my property, being a widow. At least protection may be given, my lord, so that
No,
he has not at least threatened me.
Answer the query of the court.
Yes, my lord.
What was the order last passed by the jurisdictional magistrate?
Sorry, my lord.
What was the order last passed by the jurisdictional magistrate on your application under section 1?
My lord, is pending. Report was called for. Whether
Lecture P3.
44, my lord.
It should be disclosed.
Page 44. Direction to maintain strict law and order over the suit area. Page 44.
That is where the report was called for.
8 July 2026.
We all are the female member. Being a female member, they tried to grab.
পুলিশ রিপোর্টটা দিয়েছে পুলিশ রিপোর্ট ওখানে দিয়ে দিয়েছে
Very well, if occasion so arises, give protection to the petitioner and let him proceed with the application under section 175.
144 has been disposed of, my lord. And that too, there was a direction by the police to maintain.
Wait.
Lordship, protection in the sense that in a private dispute, Lordship, the protection, the mode is a bit different.
No, it's not a private dispute.
No,
He is
it's a breach
alleging
of peace.
that
That
he is being threatened by the private respondents with a motive to grab the property.
In Lordship, let the police patrol, let there be a direction. Usually there is a
protection to be provided if occasions well.
if occasions. Yes, Lordship. Lordship. Lordship.
Affidavit of service filed on behalf of petitioner is taken on record. Petitioner alleges threat and intimidation by respondent number 5 to 12.
4 to 10.
4 to 10, man.
By respondent number 5 to 12.
12. 4 to 12.
By respondent number 4 to 12. By respondent number 4 to 12. With a with an oblique motive.
Block করে দিয়েছে রাস্তা।
To grab the property of petitioners. Stop. Alleging due to inaction on the part of the concerned police authorities in registering FIR, a proceeding under section 175(3) was petitioner moved jurisdiction magistrate under section 175(3) BNSS. Stop. Such proceeding is pending.
No,
Already
Before the
disposed of, my
jurisdiction
lord.
magistrate.
Executive magistrate.
But no, before the jurisdiction magistrate, no.
The 164 is.
I am asking you whether you have filed any application under section
No,
175(3).
in the
Then why you
judicial
have said yes?
the executive magistrate is that is before was the 144.
I was under the impression that you have initiated a proceeding under section 175(3).
No, my lord. 156 clause 3 has not been.
Not been done.
The executive
No, he's
magistrate.
not done anything like that, Lord.
Then
163 was BNNS was filed.
That is
yes, that is 163 BNSS.
BNSS.
For maintaining peace and tranquility.
That has been done.
That has been disposed of.
Then why you have made a wrong submission?
Thereafter,
Court is asking you specifically whether you have taken steps under section 175. Otherwise, you have no. In that event, you have no case. You have to approach the jurisdiction magistrate.
thereafter also.
Sure.
Thereafter also several
Service filed on behalf of petitioner is taken on record. Next paragraph.
Thereafter also several
learned advocate
representation also
the
given.
petitioner alleges inaction on the part of the concerned police authorities to take steps based on complaint lodged. Stop. It is submitted that complaint of the petitioner is yet to be transformed into an FIR. Stop. Petitioner prays for direction upon the concerned police authorities to take steps and to register FIR. To register FIR, take steps to register FIR and initiate criminal prosecution and conduct investigation in accordance with law. Next paragraph, state respondents and private respondents are represented by learned advocates. Next paragraph, there is an alternative remedy available to the petitioner under section 175(3) BNSS 2023 in the event there is inaction on the part of the concerned police authorities as alleged by the petitioner. In this regard, reliance is placed on the judgment of the Supreme Court reported in 2007-6 SCC 171, Aliu Padamsi and others versus Union of India and others. Next paragraph, in view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdiction magistrate in pursuit of remedy. Parties to act on the server copy. Next.
My lord,
Sorry.
My lord, admitted fact is that the property is mine, my lord.
Sorry.
Being a widow, they are trying to grab my property.
Yes. Please call the next matter.
Item number 12.
Item number 12, I am for the petitioner. This is wrongly filed in the
Group 9 matter. It is relating to Group 6 matter.
Group 6?
Yes,
Then
madam.
why you have
Wrong-
filed
wrongly
before this
filed.
court? At the time of call, learned advocate representing petitioner submits that issue involved in this writ petition relates to the issue involved in this writ petition comes under Group 6 of classification list of different types of writ proceedings. Stop. Hence, present writ petition is released and be placed before the bench having determination. Next paragraph, leave is granted to the petitioner to amend the presentation form and pro forma page of the writ petition and to reclassify the same accordingly. Yes. Next,
Your Lordship, I am
Item number 13.
of the petitioner. Your Lordship, praying for not this week.
yes,
Praying for not this week.
praying for
Not this week.
why?
Service has not been completed yet. Service has not completed yet.
Why you have stated that matter is to be moved on a particular date?
Clerical
It was filed
mistake.
31st of July. What is the prayer made?
Your Lordship, I am not aware of the matter.
Who is appearing? You are appearing for the petitioner.
Yes, yes.
You are
My senior, my senior.
Who is your senior?
Fasir Rahman Mullah.
Where is he?
He, because of his health issue, he did not come today.
What has happened to him?
Back pain.
You have served copies upon the other side. Upon the state.
I am not aware. Clerk, no.
At the time of call, accommodation is paid for on behalf of petitioner since learned advocate is unwell. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on August 2026. So however, it is made clear that no further adjournment shall be granted on the next.
Much obliged.
Item number 14.
Well, at item number 14, I beg to appear on behalf of the petitioner. My lord, this is my affidavit of service, my lord. All parties have been served, my lord. My lord, there is a very innocuous prayer in this application, my lord. What has happened, my lord? My water pipeline has been deliberately disconnected, has been in fact broken by the private accused persons. My lord, I am seeking police assistance for restoration of my line because that is being obstructed. Now, my lord,
just a minute.
वो बाद में करते हैं एक बार पहले DUTH WEWALE. Service complete.
Why pipeline
Millet.
supply was water supply was
Millet, that is what
disconnected?
now I'll say. Millet, what has happened, Millet? The private respondents and the petitioner. Millet, petitioner is a practicing advocate of this honorable court, Millet, and the private respondents all reside in a complex in Howrah. Now, Millet, what had happened? The private respondents had made an illegal construction inside the building. That was intimated to the necessary authorities. When no action was taken, the petitioner made an writ application. Millet, these are the orders. I'll place these orders, Millet. Millet, this honorable court, Millet, we had filed a writ before this honorable court. Now, Millet, the writ was initially admitted. The first order, Millet, is on 1st of April 2026. Now, Millet, the writ was admitted. Millet, the court had directed the municipal authorities to conduct an inspection. Now, Millet, we'll see the second, Millet, just turn 3 pages, Millet, the 2nd of April 2026 order, Millet. That is a very important order, Millet. Now, Millet, what had happened, Millet? Millet, a report was filed by the Millet, 2nd of April 2026. Millet, a report was filed by the municipal authorities that when they had gone to remove the illegal construction, Millet, the municipal authorities were obstructed by this by these private respondents. Now, Millet, this order was intimated to the court. Millet, the municipal officers, Millet, were also annexed the FIR, Millet. An FIR was initiated against the private respondents for obstructing the public servant from carrying on his duty of demolishing the illegal structure. Now, Millet, what happened? The court took cognizance of this. Now, Millet, thereafter, Millet, the court directed you further go take police assistance. On 20th, Millet, with police assistance, Millet will see the order in three leaves after, Millet. 20th of April 2026, with police assistance, the illegal structure was demolished. Millet, this honorable court directed if there is any further structure which the municipal authorities find, which is an illegal construction, they are free to take action against that also. Now, Millet, pursuant to this order, this writ was disposed of. Now, there were several other illegal constructions. The municipal authorities, Millet, this is the order, Millet, on page 31, annexure P2 of my writ application, they give another notice to the private respondents that, look, there are further illegal constructions. Please demolish the illegal construction inside the premises. Now, Millet, as a retaliation, Millet, what they do is, while I am not at my house, this is the intimation given by the authorities. This is the genesis of the dispute. Now, Millet, since these are all...
Where is the genesis of this dispute? Which document?
Millet, this dispute, Millet, since Millet will see the Bali Municipal, page 31, page 31, my lord. Millet, because of my actions, the illegal constructions done by the private respondents is being demolished. Therefore, there is a vendetta against me. While I am away from my house, Millet, I have annexed the pictures, Millet, at page 38, Millet.
But there is an order of demolition.
Millet, that is
page 32.
Millet, that's a self-demolition order which is not done, my lord, by them.
And then you have to challenge
Millet, Millet, I am not on that. I have challenged that. That is pending. What now, Millet, because of this, Millet will kindly turns to page 38. As a retaliation, these private respondents, Millet, inside the building, what they do is the water line that goes to my house, they break that. Now, Millet, for the past 25 days, I am in my house without water. Now, Millet, I intimate this to the police. Police lodges an FIR. Millet, investigation is going on. Now, Millet, despite investigation going on, whenever I am going to...
you are praying for restoration of water supply.
With the help of the police.
Otherwise, you are not in a position to carry out repairing work.
25 days I am without water. Till today I am without water, my lord.
My answer has been given by my London friend. Police has already taken steps. FIR has been registered. And investigation is in progress. Now, if a lordship...
The citizen is without any water.
It's absolutely...
Due to nuisance by the private respondents.
Yes, it's a dispute amongst the inside parties, those who are residing, resident.
To give protection so
Well,
that
very well. As your lordship
water supply can be restored.
Definitely.
Yes, that is my only...
That is one of the fundamental right to get the water. As I understood.
Issue. Affidavit of service filed on behalf of petitioner is taken on record. Stop. It is submitted by learned advocate representing.
May I
petitioner.
submit report, police report we have got it. Everything is there, my lord.
It is submitted by learned advocate representing petitioner. That petitioner's premises is without any water supply for last 25 days due to obstruction made by respondent number.
Respondent number, 7 to 12, I'll just confirm.
7 to 12.
According to the last
Obstruction made by respondent number 7 to 12. Have you served upon the
everyone, complete
7 to 12? Petitioner prays for direction upon the concerned police authorities. Direction upon the which would permit the petitioner
police investigation is in progress.
restore supply of water. To restore water supply. To restore water supply to petitioner's premises by carrying out necessary repairing work. Stop. It is submitted that previously attempts were made to complete repairing work for restoration of water supply, but such attempts failed due to obstruction made by private.
We've lodged a GD to that effect also.
Stop. It is also next paragraph. It is also submitted on behalf of petitioner that an FIR has that an FIR was drawn up being Lua Police Station case number 382 of 2026 dated 28 July 2026, and investigation is being carried out. Stop. To that extent, next paragraph. To that stop there. To that extent, a communication is communication dated 5th August 2026 of Inspector of Officer in Charge, Lilua Police Station, is filed on on behalf of state respondent and same is taken on record. Stop. In the said communication also corroborates the statement submission made on behalf of the petitioner relating to registration of FIR. Next paragraph. Copy of the said communication dated 5th August 2026 be made over to the learned advocate representing the petitioner. Next paragraph. Be that as it may, concerned police authority Officer in charge, Lilua Police Station, being Respondent 6, is directed to provide assistance to the petitioner, which would enable him to carry out necessary work for restoration of water supply to his premises. Stop. Next paragraph. Writ petitions.
Only one humble prayer, my apprehension, that previously also they are so indolent that they do not have any concern for the public authorities. They stop them. Kindly just keep this writ pending. After 1 week, when it is done, a compliance report be filed.
আচ্ছা একটা জিনিস করো, ডিসপোজ হওয়ার আগে করো, কি বললাম সেন্টেন্সটা? Directed stop within to the premises. Stop. Petitioner shall intimate respondent number 6 the date when the date when such work is to be carried out, based on which police assistance shall be extended to the petitioner on the particular date. Writ petitioners are disposed of parties to. No.
They do not believe in law.
Yes. Next matter.
Deeply obliged, my lord.
Item number 15.
Lordship, I'm just praying for today's accommodation, awaiting instructions, Lordship, awaiting instructions.
Why you have not obtained instructions?
Actually, some instructions are still to be gathered, Lordship.
Notice of service, affidavit of notice.
Your learned advocate representing state is praying for time to obtain instruction.
Sir, we have served the notice on 5th of August.
Yes, but still he has no instruction. He is seeking adjournment.
Lordship, keep it tomorrow. Tomorrow.
Sir, tomorrow.
Well, not today.
What, sir?
Not today. Tomorrow. Come back tomorrow.
Okay, sir.
Do you have any difficulty tomorrow?
Sir, we are 5 petitioners in person and we have to leave our office and come to the court. From last 10th of August, we are coming daily because our matter was first stated on 10th of August. From then, we are coming daily because of hearing that any day it might come. So this is creating hardship to us, if you kindly consider that. And because we are 5 petitioners in person. So I am a chartered accountant and they are my staff. They are working in some office. And he's my brother.
It is a prayer in the writ petition.
Sir, the pair is that the police officials have misused the law without serving any section 35(3) notice, beaten my brother, converted a civil matter to a criminal matter, arrested 5 of us without serving any notice, and then making.
Who is the petitioner?
Sir, I am petitioner number 1.
I am petitioner number 2.
Now, you are not the sole petitioner, whether you can represent others.
No, sir, I'm not. He's petitioner number 2 and they are petitioner number 3, 4, 5. All are coming. All are present here.
You can represent yourself, but can you represent others?
No, sir, I'm not representing. They are representing themselves, sir.
In one matter. 5 petitioners will make separate arguments.
Sir, the matter is the same. The case is the same, but the case is the same, sir. All were arrested in the same cases, sir. In the same case, sir.
How the petitioners are related?
Sir, he is my brother, and they were working for me, and they were working in. They are my staffs.
Now, how you are agreed by the action of the police authorities?
What, sir?
How you are agreed by the action of the police authorities?
Sir, because the police converted a civil matter to a criminal matter. And then came to our office, beaten my brother badly.
Who is the complainant?
Sayan Adhikari is the complainant.
Sir, private respondent, number 5.
Have you served notice upon him?
Yes, sir, sir.
Show me that you have served notice.
Yes, sir. But, sir, he has not accepted the notice.
We have served that notice 2 times.
What is the complaint?
Sir, he complained that we have taken money from him and we have not done his work. But that was a civil matter. It was clearly explained to him that we are taking money on best effort basis. This is not a guarantee that we will do your work. We have clearly understood
When
that.
you have served upon respondent number 5, show me. Now, this respondent number 5 is the complainant.
Yes, sir. Shayan Adhikari. Sir, yes. This Shayan Adhikari.
Shayan Adhikari. Yes. How you have tried to serve?
Yes, sir. This is.
Question.
So he refused to accept.
We will do one thing. I will direct the concerned officer in charge to send a notice to respondent number 5 for his representation before this court. And I'm fixing a date. Not grateful. Grateful.
And sir, and my lord.
Hard when you are petitioner number?
I'm petitioner number 1.
1.
Yes, sir. Yes.
Petitioner number 1 appears in person and submits that notice was served upon respondent number 5, but same was refused. Next paragraph. It appears from the submission made on behalf of respondent number 1. Respondent number 1. It appears from the submission of petition number 1 that respondent number 5 is the complainant. Is the complainant? Stop. Court desires to hear respondent number 5 on the next date. Stop. Inspector in charge / officer in charge, Narayanpur Police Station, Bidhannagar Police Commissioner is directed to communicate this order to respondent number 5 but he stays at Howrah.
Yes, yes, my lord. My lord, he has filed a cyber complaint also on 28th of June. And then on the next day, he filed a complaint in Narayanpur police station. The first complaint he filed in cyber portal, NCRP portal, we applied to the Nishinda PS on that day only. Still, and when he filed a complaint in Narayanpur police station, we tried to make them understand that a matter has already been filed by him, and we have given our explanation to Nishinda PS, but the Narayanpur police station was not ready to listen anything. They were just trying to create a case, manufacture a case, because they were hired by the private respondent.
Who is hired by private?
Sir, the police.
Police.
Yes. Police has worked as a private recovery agent.
Terms and conditions of
We have attached in the annex.
What are the terms and conditions of hiring agreement?
My lord, because the police acted as a private recovery agent.
How do you know?
Because if you go through the case, you will also know, understand, sir. My lord, what happened?
Make these wild allegations. Okay. Without any record. You are before the court of law. You are not having conversation in your drawing room.
Okay. Sorry, my lord. Sorry, my
What is this? You are permitted to appear in person. That doesn't mean that you will make submissions before the High Court, whatever you like.
My lord, I'm sorry.
If you do not know how to address the court, and then engage a lawyer.
My lord, I'm sorry. Kindly pardon.
Do you have any proof or any document based on which you are making these bold allegations?
If you, Lord, allow me to submit this.
Sorry, not today.
Okay.
And is it part of record? Is it part of record?
So this is a Facebook social media
Can
post.
you take out anything from your pocket and place it before this court.
This is by the Bidhan Nagar police station.
Whatever may be. If it is not part of record, you cannot make any submission based on such document.
Okay.
Don't take it so lightly.
My lord, I'm not. I'm sorry for that word. I'm very sorry.
Making bold allegations against the respondent authorities without any basis. And during course of hearing, you cannot take out anything from your pocket and place it before this court. If it is not part of record.
Okay.
Mr. Das, there are 5 petitioners, out of which petitioner number 1 is appearing in person and making submission. There might be police overaction as it is complained of. And now, complainant is not represented today. Now, court desires to hear complainant because he is the person who has lost complaint based on which perhaps any steps have been taken by the police authorities. Now, complainant has refused the notice as it is disclosed by filing by affidavit of service. I am directing the officer in charge of inspector in charge or officer in charge of Narayanpur police station to send a notice to the complainant. But the problem is, the police station is under Bidhan Nagar Police Commissionerate, but the complainant stays at Howrah. So send a notice by post.
May I suggest something, Lordship? My lord, I do not know what is the nature of the allegation. I will be very candid, Lordship. I haven't been able to go through the brief. May I just come back, speak to the police authority, because what might happen, getting a notice from the police, even if it's a genuine complaint, the complainant might get intimidated. Because, Lordship, let us be very candid about the fact that getting a notice from the police or police visiting the house of anybody, any common citizen, it creates a sort of stigma, if I may put it that way. So may I just come back, my lord, kindly keeps it tomorrow, or Lordships, as per Lordship's convenience. Let me also speak to the officers what has happened. If required, I will speak to the higher officials also. If there's a complaint of overaction, that will be taken care of.
We will take instructions since petitioner is appearing in person. He is praying for fixing a date because every day he is watching the proceedings by physically presenting himself before the
My lord, I do not stand in the way
affidavit of service filed on behalf of affidavit of service filed on behalf of petitioner is taken on record. Next paragraph. In spite of service of notice, respondent number 5 is not represented. Stop. Respondent number 5 is the complainant. Stop. Learned advocate petitioners are directed to send another notice to respondent number 5. Directed to serve another notice to respondent number 5 by 7 days from date. Stop. Next paragraph. By 7 days from date and file affidavit of service on the next date. Next paragraph, list the matter as 2 p.m. fixed list the writ petition as 2 p.m. fixed matter on on 8 September 2026. Stop. It is made clear that if in spite of serving notice, respondent number 5 remains unrepresented on the next date, comma, matter shall be heard in absence of respondent number 5.
Thank you, my lord.
Great. Next, call other matters. Learned advocate for the Mr. Learned advocate for the state respondents is directed to obtain instructions.
Item number 149.
RJ, my learned friend said that he will give the report.
My lord, I haven't got the report. All the cases have not been. All the cases have not been tabularized. Report test yet?
Last day I indicated the only prayers remains is the disclosure of cases. He said he will furnish. You said you were there.
You have to intimate.
Yes, lordship.
My lord,
It has
kindly
to be.
dispose it off with a direction within 7 days they will furnish. Every day I come, it is good for him, it is good for me.
Good for me, no adjournment হলে আমি ফি পাই না।
তাই জন্য বলছি তো ডিসপোজ অফ।
13th August or today is 20th August. At the time of call, Mr. Das learned additional government Peter pressed for accommodation. Intimate number of criminal prosecutions pending against the petitioner. Stop. Hearing of this matter stands adjourned for hearing of this matter stands adjourned. Stop. Is the matter under the same heading for further consideration on? Second September 26.
At least on that day he will come with the report. One indication.
I want to get this disposed of.
Much of this.
Item number 150.
Your Lordship's order dated 29/6/2026. Paragraph number 4. Very contentious matter, but not much to argue right now.
Yes, report.
Lordship, this is the report, Your Lordship. Except 6 cases, no other cases are pending against the petition.
They could give us.
Yes.
They could give us the list then.
So everything is annexed over here.
Huh?
All the reports are annexed over here. It's annexed.
We'll take that.
Yeah.
They have provided court
Court direction.
Either number, not this case number 98.
এখানে কটা লেখা ছিল?
Yes, prosecutions are disclosed. Criminal prosecutions pending as the petition are disclosed. If they could give a copy to him.
Yes, Your Lordship.
Paragraph 3. Just Your Lordship can dispose of the writ. Only thing, my lord, keeping all other my lord, legal options open, what we are entitled to law. Because we've taken other
in
points.
terms of the order dated 29 June 2026. a report. Oh, my lord, your lordship will not dictate the order. There's two more facts which your lordship must know. Then your lordship dictates it. It will get disposed of. But that is, one is that I was arrested, and my lord, the proceedings in which I've been arrested, my lord, there are a lot of press connected to that. Now the issue is that since my arrest, there's been charge sheet which has already been submitted. Your lordship would kindly record that, because all my avenues will be before another court. So
So far, Vidhannagar North PS case number 98 of 2026.
Yes.
Charge sheet
Only
filed.
98. Yes. Only 98. We've come to learn that because we were there in court, charge sheet has been filed. So your lordship would indicate that because there are connected
When
press.
filed?
When filed? When filed?
Charge sheet number and date.
We've not taken the charge sheet yet, because we've challenged. It's also to your lordship's notice. We've challenged the jurisdiction of that court because we've been shown to be a public servant, and that is the reason why.
Very well, that will be recorded in the order.
Yes.
Issue.
But we propose to take it on the next day. So the charge sheet.
Matter is hard in terms.
Last disposal.
How did it 29?
Disposal.
29 June 2026.
Abhi kare fill it up.
When learned advocate representing state respondents has filed a report dated 11 July 2026 of Director General and Inspector General of Police West Bengal, and same is taken on record. Copy of the said report dated 11 July 2026 is made over to learned advocate representing petitioner. Next paragraph. Report discloses criminal prosecutions which are pending against the petitioner, including Vidhannagar North Police Station case number. Vidhannagar North Police Station case number 98/26 dated 9th June. Dated 8 June. It is 8 June or 9 June, Mr. Banerjee.
My lord, it is just a minute, my lord, I'll tell you, lordship. It's 8 June or 9. Just a minute, my lord. 8 June or 9 June.
Because report report tells it is 8 June.
Whichever date report shows goes by the report.
Dated 8 June 2026.
Our record shows 9 June, but whatever the report says, whatever the report says, my lord, your lordship goes by that.
8 June 2026. Stop.
R1.
Mr. Shobhusachi Banerjee, learned senior advocate representing the petitioner, submits that charge sheet has been filed before the jurisdiction. Charge sheet has been filed before the court below. Before the court
below. Grateful.
Before the court below, in connection with Vidhannagar North Police Station case number 90. In connection with Vidhannagar North Police Station case number 98/2026 dated 8 June 2026.
Cognizance has not been taken.
Next paragraph. In view of disclosure of criminal prosecutions in the report dated 11 July 2026, no further order need be passed on this writ petition, and the writ petition is disposed of. Stop. However, petitioner shall be at liberty to take steps in accordance with law if so advised.
No, not if so advised. If any available. Not advised. Tomorrow my advice might not be taken. If any available. In accordance with law, if any available.
Shall be at liberty to take steps in
accordance with law. That's it. That's all. That's all. Very good. Grateful. I didn't want to trouble your after morning. Grateful.
Item number 151.
151.
You are 151.
152. Petitioner. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. However, state respondents are represented by learned advocate. Stop. Next paragraph. From record, it appears on 1st of July 2026. Prayer was made to adjourn the hearing of this writ petition, and same was allowed. Stop. It appears petitioner has appears that petitioner has lost interest. Stop.
writ petition stands dismissed for default. Parties to act on the server copy.
Grateful Lordship. 152 এর রিপোর্টটা দাও।
Item number 152.
তোমার কাছে
I appear on behalf of the petitioners, my lord.
Yes.
My lord, on the last date, the state was requested to furnish instructions, my lord, by the last order, my lord.
Last provision, my lord, can you change the second?
What is the case made out in the writ petition?
My lord, if my lord takes up page number 158 of my writ petition, my lord, the petitioner is an accused, my lord, in respect of, my lord, a case registered with the Enforcement Directorate in relation to the primary recruitment scam, my lord. Thereafter, my lord, he was granted bail, my lord, by 2 orders, my lord, and now, my lord, post his, my lord, release, my lord, there are people, my lord, who are contacting, my lord, the petitioner and threatening him with coercive action. And my lord, with my lord, if my lord takes up page number 160, my lord.
168.
160, my lord.
169.
No, my lord, 160.
160.
Yes, my lord. That, my lord, if I may place the letter, my lord.
168.
That the following persons taking advantage of the changed political situation are threatening me and creating fear that they will drag me into false cases in connection with the same school teacher appointment scam in lieu of money. They are demanding money from me under threat that if I don't pay, they will lodge false information report against me in respect of the same cause of action for which I am already being investigated and tried by the CBI and the Enforcement Directorate. The names, addresses, and contact details of the threatening persons are as follows, my lord. My lord, I have given the names of the people who are constantly threatening me, my lord. Thereafter, my lord, my lord, in these circumstances, my lord, I made this writ application, my lord. My prayers are in page number 37, my lord. Therefore, praying an appropriate direction upon the officer in charge, Balagarh Police Station, and the Superintendent of Police, HON'BLE, to, my lord, register, my lord, a complaint, my lord, against the 15 people named, my lord, who are constantly threatening me of filing false cases, my lord, and demanding money, my lord, from me, my lord.
Approach the appropriate forum.
My lord,
For registration of FIR,
My lord,
why the writ petition will be entertained? And that too, you are making out a case is made out, as you have drawn attention of this court to page 160, that you are anticipating that based on the threat, steps will be taken against the petitioner by lodging a complaint. Whether in anticipation any order can be passed in exercise of writ jurisdiction.
not only, my lord, threat.
If any steps are taken, if you are arraigned in a proceedings, then you take steps in accordance with law. But prior to that, how this court can protect you?
Yes. My lord, these 15 persons, they are not only threatening me, my lord, with false cases, my lord, they're also threatening me with injury, my lord, physical harm and injury. Therefore, my lord, my complaint ought to have been looked into, my lord, by the officer in charge in respect of the representations I have made to him. My lord.
By presenting this writ petition, yes, anything you want to submit?
My lord, that is the point. I would have also taken no cause of action, but NCR has been, they have been bound down.
By
They've been
presenting
given.
I am for the 1 to 5.
case is made out
1 to
inter
6.
alia seeking direction upon the concerned police authorities to register FIR based on complaint lodged. Stop.
153 a report.
Next paragraph, state respondents are represented by learned advocates. Next paragraph. There is an alternative remedy available to the petitioner if content of the petitioner is not transformed into an FIR, and no criminal prosecution is initiated. In this regard, reliance is placed on the judgment of the Supreme Court reported 2007-6 ACC 171, Aliu Padamsi and others versus University of India and others. Next paragraph. In view of availability of alternative remedy, present petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach the appropriate forum in pursuit of remedy. Parties to act on the server copy.
My lord, my affidavit of service may be taken on record.
Affidavit of service filed on behalf of the petitioner is taken on record.
Item number 153. Did I appear on behalf of the petitioner?
No.
But if my lord takes up the last order, my lord.
Yes. I am on last order.
আলাদা
Yes, report.
Those are the only two cases pending against the petitioner as on date of the report being 13th of July 2026. No other cases are pending.
Give a copy to him. Issue. In terms of order dated 30th June 2026, a report dated 13 July 2026 of Deputy Inspector General of Police within bracket legal, West Bengal is filed today and same is taken on record stuff. Copy of the said report dated 13 July 2026 is made over to the learned advocate representing the petitioner. Stop. Next paragraph. Vide said report dated 13 July 2026. Criminal prosecutions which are pending as the petitioner are disclosed. Next paragraph. Hence, next paragraph. Due to disclosure of criminal prosecutions by the concerned police authority in terms of order dated 30 June 2026, no further order will be passed on this petition, and the same stands disposed of. Parties to act on the server copy. Next.
Item number 154. My lord, for the petitioner. Now, there was multiple raids at my home without any FIR that was drawn. That was my primary allegation that I have made. And there was mob attack also.
Yes. You have to obtain instruction, Mr. Das.
But not found.
You were requested to represent state.
Yes, my lord. I have a report.
Without any FIR, without any proceedings, house of the petitioner was.
Mother kindly takes up the complaint that
petitioner was going to the house of the petitioners.
Mother, is that the case which has been made out in the
police authority was going to the house of petitioners?
Is that the case which has been made out in the writ petition? Mother, the complaint is at page 17.
No, what is your instruction?
His case is that
the case is made out.
No police had gone to his house.
Weak case.
No police had gone to his house. He has complained there was an inquiry conducted for which they had gone. It is not a raid. He will complain that certain persons are coming and threatening me. There's hooliganism. Police will go to his house. He will turn around the facts and say that the police is coming and raiding my house. That is not fair, Lordship. That is not fair on the part of the petitioner. This is known as spin doctory. Lordship kindly takes the complaint that he has filed. Address to the page 17. Joint Commissioner of Police Crime, address to Joint Commissioner of Police Crime, DC South Suburban Division, and Officer in Charge, Netaji Nagar Police Station. Representation seeking immediate protection against apprehended false implication in criminal cases and harassments in the hand of police. That is what he says. Paragraph 4, that on 4th May, he sends this letter on 12th of June. That on 4th May, local hooligans come to my party office and making a gherao and chanting provocative slogans, and they are also threatening me that I will be implicated in malicious prosecution on charges of extortion and other charges and shall be put behind bars. That despite there being no criminal case, complaint or credible material against me, the treatment I had received from the hooligans are as if I were involved in criminal activities and am tainted, antisocial, thereby tarnishing my reputation and dignity in the eyes of society.
At least in the complaint that the
At the police, there is any...
going to the residence of the
Yes. And then it is made from statement made from the bar that this has been done.
made any statement in the body of the writ petition?
My lord, I'll just tell you. There are two.
Where is the case made out?
This is a post-poll violence.
Have you stated anything in your writ petition that unnecessarily police authorities were going to your house, though there is no criminal prosecution pending? Where you have stated? If your complaint is devoid of such particulars, in that event you have to show from the writ petition that a case is made up.
My lord, now in the prayer portion of that representation.
I do not know anything. First show me, because that was the reason
Right.
passed an order on last occasion.
Right, my lord.
Where you have stated?
I have stated that no coercive action can be taken against me.
Where you have stated that police,
That is in page
police
19.
authority was going to your residence.
My lord, in page 19. First, second, third,
Page
fourth
19.
line. Visit my residence except in accordance with law.
Page
They
19.
had been visiting my residence. That is the reason this was the representation I made out. Fourth line.
This is in anticipation.
Where you have stated that police authority was going to your residence.
Not in the body of the.
Sure.
My lord, may I just make one prayer?
My
lord,
case was it was submitted by on behalf of the petitioner. That there is no criminal, though there was no criminal prosecution pending against, though there was no criminal prosecution pending against the petitioner. Former petitioner's residence was repeatedly searched by the concerned police authority without any authority.
my lord, and there was
By the
another
concerned
fact
police
that there
officials
was
without
mob
any
attack also.
Stop. Today, Mr. Das, learned additional government peter representing state respondents on instruction submits that police authorities or police official did not go to the residence of the petitioner. For conducting search. Stop. A complaint was lodged by the petitioner.
My lord, I'll also just one more submission I want to make. There is an aide of the petitioner, AID aide, who is a man Friday, who happens to be the man Friday, Mr. Devdeep Mukherjee. He had also filed a writ petition being WPA number 13249 of 2026. Exactly same complaint, cyclostyle complaint on the same day. Exactly contents are same. Only the names have been changed and the signature has been different. I've opened that writ petition also. Word by word, it is same. Word by word.
Same advocate.
Advocate.
Similar things happen. It was all post-poll violence. They attacked.
4th May it happens. He complains on 12th of June.
And in that complaint, there was more than one allegation on more than one cause of action was mentioned.
On 12th June 2026, making certain allegations, and police official might have gone to the residence of the petitioner for inquiring the issue. Next slide. On query being posed to the learned advocate representing the petitioner to demonstrate whether any case is made out, making allegations against the police authorities relating to repeated visit by the police authorities to the residence of the petitioner. No satisfactory reply. Court does not get satisfactory reply. Stop. 155. Next paragraph. Hence, present writ petition is not entertained and same. Hence, present writ petition is not interfered with and same stands dismissed.
My lord, kindly give me some protection from the mob attack.
We will mislead the court on the first day. Unnecessarily matter is being taken up today, and I have to give you protection. Yes, please call the next matter.
Item number 155.
No case is made out. Submissions are made at the bar.
Kindly see the last order. My lord, sir. Last
Just
order.
a minute. Please file on.
Yes, I have a report, Lordship. And understand the action taken portion is last page of the report. Sir.
Issue. In terms of order dated 30 June 2026, Inspector in charge Shamsherganj Police Station has filed a communication dated 19 July 2026 and same is taken on board. Next slide. Copy of the said communication be made over to the learned advocate representation. It is disclosed in the communication that certain steps have been taken to identify accused person. Stop. In spite of taking those steps, till date, accused person is not identified. As a result whereof, said accused, as a result whereof, culprit could not be arrested. Stop. Concerned police authorities are directed to continue with endeavor to identify accused and arrest him for conducting appropriate investigation. Stop. With the aforesaid direction,
may I submit on? Kindly direct the SP Jongipur Police District to depute on DSP to supervise the case. Otherwise, my lord.
Sorry. Yes. Next matter.
Otherwise, my lord. Miscreant.
Next matter.
Item number 156.
Report.
On 30th of June, a further report was called for. The writ was filed with respect to the prayer that what are the pending cases against the petitioners.
Just a minute, my lord.
অনেকবার ফোন করা হয়েছে
Three FIRs you are aware of. Yes. Any other?
Lordship, I have a report from the inspector in charge of Chinsura Police Station. At the Chinsura Police Station, there are 3 FIRs in which he has been arraigned as an accused. Lordship, this is the report. I'm handing over a copy to my learned friend as well.
Yes, then let me dispose it of. In terms of order dated 30th June 2026, Inspector in charge, Chinsura Police Station, has filed a communication, has filed a report. No. When I will direct the police authorities to file a report, why communications are being filed? In several matters, I find it.
Well, old habits die hard. It is a habitual change. It will take, yes, it
Otherwise,
ought
I
to
have
be.
to direct to file an affidavit.
No, it ought to be in the form of a
Disclosing
report.
the pending cases. What is this?
I, as a matter of fact, Lordship, what has fallen from your Lordship, I have also indicated the same thing, that it should not be as a communication. It should be
the learned government be done.
Yes, it should not be
So
that.
this is being filed in terms of
Terms
the
of a-
order passed by the court.
Yes, Lordship, now slowly it is happening. Whatever police districts I'm coming
Some
across.
matters, when I direct the deputy inspector general,
Yes.
it comes in the form of affidavit. report, otherwise not.
Yes, Lordship kindly allows me some more time, it will change, the habit will change.
দেখি। I will give another 10 to 15 days and thereafter I will start directing the concerned police authority to file a short affidavit coming to this
No,
court.
no, I'm sure, Lordship, that will not happen.
কি বলছিলাম? Has filed a communication dated 27 July 2026 disclosing particulars of FIRs which are pending against the petitioner. Stop. Copy of such communication dated 27 July 2026 is taken on record and copy of the same is made over to learned advocate representing petitioner. Next paragraph, in view of disclosure of criminal prosecutions pending against father-in-law petitioner. দেখো তো আগে petitioner বলেছি। ওটা ঠিক করতে হবে নাহলে ভুল হয়ে যাবে। Against father-in-law petitioner. Father-in-law petitioner. No further order need be passed on this writ petition. Stop writ petition stand disposed of. Parties to act on server copy. Next. Deeply obliged.
Item number 157. What do we?
Yes. Case your case.
Lordship, I'm a medical practitioner, Lordship. Since the election results, Lordship, I have been facing harassment. People are attacking.
You have been
facing harassment, Lordship. My complaint is at page number 10, Lordship.
harassment. Page 10. Just a minute. Yes.
Lordship, my main prayer was for registration of the FIR. However, Lordship, due to the
And you know the view of this court.
Indeed, Lordship. My only prayer is we'll approach the learned jurisdictional magistrate, Lordship, kindly direct so that a police may keep a vigil in the locality so that no untoward incident that happens. Only that much limited prayer.
Yes, Lordship, as a matter of recourse, an order under 163 ought not to be passed by the Honorable High Court. Lordship kindly takes page 10, the complaint. One small paragraph saying, গত বিধানসভা নির্বাচন অতিবাহিত হওয়ার পর থেকে আমি লক্ষ্য করিতেছি যে আমার উপর বিভিন্ন সময় বিভিন্ন রকম ভাবে হয়রানিমূলক ঘটনা ঘটিতে চলেছে। উক্ত হয়রানিমূলক ঘটনাগুলিতে প্রশাসন উদাসীন থাকার কারণে আমাকে আরো বেশি সমস্যার সম্মুখীন হতে হয়েছে। সেই জন্য দিনের পর দিন আমার উপর হওয়া অহেতুক হয়রানি বেড়েই চলেছে, যাহা কিনা সুষ্ঠুভাবে সমাজে বেঁচে থাকার পরিপন্থী. So sorry.
Yes.
Where are the particulars? Absolutely vague. One paragraph just written, this is happening, that is happening. What is happening?
Lordship, for that reason, I have placed my submission only that we will approach the learned jurisdictional magistrate. Also, Lordship,
You have to make out a case for obtaining a direction upon the police authorities to maintain peace and tranquility.
Lordship,
Nothing, no materials are there, no ingredients are there.
indeed, Lordship, when we'll approach the jurisdictional magistrate, we will give a whole details, Lordship, as to why we have this apprehension that we are the victim of such incident, Lordship.
Before this court tried to appreciate my predicament, there are no ingredients requiring direction upon the police authorities to maintain peace and tranquility and keep busy. Where are the ingredients? Where are the ingredients?
Lordship,
This is the
subject to
nature
correction.
of
Lord-
complaint rightly pointed out by your learned friend.
Lordship, I'm aware of that fact, Lordship. That is the reason I did not place my complaint. I'm aware of the points, Lordship. I'm only praying so that as a normal recourse, which any investigating
Let me
officer,
dispose it of.
Indeed.
Think you leave to approach the jurisdiction.
only
Yes,
a normal routine so that no untoward incident that happens.
A matter is taken up for consideration. Learned advocate representing the petitioner based on complaint dated 5th June 2026 pays for direction upon the concerned police authorities to register FIR and initiate investigation. Stop. Mr. Das, learned additional government period representing state respondents, has opposed this writ petition, and it is submitted that there are no materials disclosed in the complaint dated 5th June 2026 lodged by the petitioner requiring police authorities to take certain steps. Next paragraph. Be that as it may, as prayer is made on behalf of the petitioner for registration of complaint, comma, for registration of FIR, comma, liberty is granted to the petitioner to approach jurisdictional magistrate under section 175(3) BNSS 2023 in the event steps are not being taken by the concerned police authorities. Next, writ petitions are disposed of, parties to act on the submitted.
Lordship, my affidavit of service.
Affidavit of service filed on behalf of petitioner is taken up.
Much appreciated.
Item number 158.
File. 158. Yes, who is for the petitioner? Yes. I'll dispose it of based on this, instead of
taking the
dismissing the matter.
Yes, yes. Because there was an order
Because I
on.
have directed.
Yes, yes, Lordship.
Issue. Matter is taken up for consideration when no one appears for the petitioner and no accusation is paid for. Next paragraph. However, Mr. Surjanil Das, learned additional government period representing state respondents, appears on behalf of state respondents and files a report dated 10th August 2026 of Inspector in Charge, Pauria Police Station, Howrah Rural District, and same is taken on record. Stop. Video, next paragraph. Video said, by said report dated 10th August 2026, criminal prosecutions which are pending against the petitioner are disclosed. Stop. In view of disclosure of criminal prosecutions running against the petitioner, no further order need be passed on this with petition, and same stands disposed of. Parties to act on the server copy. Parties to act on server copy. Next.
Item number 159.
I am for the petitioner, my lord.
Yes.
Below
Just a minute.
Well, I am for the private respondent.
Yes, what is the matter about?
Milord, here the private respondent are making one unauthorized construction and encroaching my land. Milord, we have made the representation to the police station and other authorities. Milord, they have also prepared one writ application which was dismissed by the Honorable Court, Milord.
This court?
Yes, Milord. Milord, if such construction is
Same fate is awaiting so far your petition is come.
Milord,
there should not be any discrimination.
No, Milord.
Already, my lord, one title suit is pending,
We have
challenging
filed
the.
one title
Who has
suit.
filed that suit?
Yes,
They have
Milord.
filed.
Yes,
They have
we
filed
gave
the suit.
injunction order. I have annexed the injunction
Injunction
order.
was taken.
Milord, violating the said injunction order, they are.
Where is that injunction order?
Milord, I have a
Page, which page?
the page.
You don't have brief.
I just got the.
On page number 42.
Yes. 18th May 2026 order.
Yes. In spite of that injunction order, they have violated and started the.
একটু আস্তে আস্তে একটু আস্তে তুমি এটা একটু করো না
একটা রিপোর্ট
দেখে ডিরেকশন দিলে আমি ক্লিয়ার
This is an ex parte ad interim order of injunction.
When they started,
Now, if there is an ex parte ad interim order of injunction, if that is violated, then you have to file an application under Order 39, Rule
2A, Milord. We have also filed that, but they have violated forcefully, encroaching the
Now,
land.
what is the fate of that application? Under
Milord, it
2A?
is still for SR.
So why you have filed the petition?
Milord, if they, Milord, if they make the construction,
then that application will become infructuous.
Yes, Milord. So,
learned advocate representing
please
learned advocate representing the petitioner submits that construction is being made by private by respondent numbers 5 to 7. You are representing by respondent numbers 5 to 7 encroaching land of the petitioner, thereby prompting the petitioner to approach this court with the present writ petition, seeking direction upon the concerned police authorities to take steps. Stop.
Without plan, Milord.
It is also submitted that an application, it is also submitted that an ad interim order of injunction was passed by civil court on 18th May 2026 in title suit number 571 of 2026. Thereby directing the defendants or thereby restraining the defendants from encroaching scheduled property of the petitioner for a limited period, or from encroaching scheduled property for a schedule or for from encroaching suit property for a limited period. Stop. Petitioner prays for direction upon the concerned police authorities, which would restrain private respondents from making construction encroaching land of petitioner. Next paragraph, state respondents and respondent numbers 5 to 7 are represented by learned advocates.
Denied and disputed.
Stop.
What allegation?
Learned advocate representing private respondent numbers 5 to 7 disputes submission made on behalf of petitioner. Stop. Next paragraph, it is submitted on behalf of state respondents that issue involved in this petition is civil in nature, requiring the parties to approach appropriate forum. Next paragraph, from the submissions made on behalf of respective parties, it appears that alleging violation of the order dated violation of ex parte ad interim injunction dated 18th May 2026. Petitioner filed an application before the civil court and same is pending. Next paragraph. Petitioner needs to pursue remedy based on application filed wherein case is made out that by making construction, petitioner violates ex parte ad interim injunction dated 18th May 2026. Stop. Police authority is not the appropriate authority to decide whether constructions made by the petitioner violates order dated 18th May 2026 of civil court or not. Next paragraph. Or not. Next paragraph. Hence, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach the to press his application pending before the civil court, alleging violation of order dated.
No such application is annexed with this writ petition. Neither the allegation of violation is made out in the pleadings of the writ petition.
Yes, my lord.
Next matter.
My lord, a direction of the police report may be given to me.
Yes.
Police.
No, I have not relied upon this.
Grateful.
Item number 160.
Lord, I am for the private respondent, my lord. Respondent number 7.
Time of call accommodation is paid for. Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. Iowa state respondents are represented by learned advocate.
My lord, I appear on behalf of the private respondent, my lord. Respondent number 7, my lord.
Iowa state respondents and respondent number 7 are represented by learned advocates. Next paragraph. From record, it appears that accommodation was paid for on 30th June 2020. Accommodation was paid on 30th June 2026, which was allowed by this court. Stop. Next paragraph. It appears petitioner has lost interest. Writ petition stands dismissed for default. Parties to act on server copy. Next.
Obliged, my lord.
Item number 161.
Lordship, item number 161, I'm praying for not this week, Lordship.
Why?
Lordship, Mr. Mukherjee is appearing in this matter. He is out of station for a matter, Lordship. He will not be present tomorrow.
Roman Bushra appear for it's of same post-school violence. They're against him.
At the time of call issue. At the time of call, accommodation is paid for on behalf of petitioner on the ground of learned advocate. However, state respondents are represented by learned advocates. Stop hearing of this matter stands adjourned. This the matter under the same heading on 7th September 2026. Oh, 7th is monthly day, 8th September.
Item number 162.
My lord, I appear on behalf of the private respondent, my lord. Respondent number 7, my lord.
এই শোনো সেম অর্ডার করো আগে যেটা করলাম না হ্যাঁ রাইট 160 রাইট 160 কবে 30th জুন তো দেখো তো পাঠিয়ে দিন। না না same order হবে না কেটে দাও who is for the petitioner you are appearing for the petitioner
163
in item number 162 না হবে না ওটা accommodation থেকে ছিল ওটা আলাদা। এসো 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 চলে যাবো At the time of call, no one appears for petitioner and no accommodation is paid for. However, state respondents and respondents 7 are represented by learned advocate staff. Writ petition stands dismissed for default. Parties to act on service.
Obliged, my lord.
Item number 163.
I'm for the private respondent. I'm for the petitioner.
Have you served notice upon the added respondent?
Yes. Yes, your lordship. Yes, your lordship.
Where is the notice? Where is ability to service? Anybody's
My lord, I am appearing on behalf of the added respondent, private respondent number 5.
What is your instruction?
My lord, I have been instructed that I have been instructed for praying for reconciliation between the parties, and that's all he is praying for.
What is the case made out in the
The case is I am the mother-in-law. So the case is after the marriage, suddenly the attitude of the uh, daughter-in-law changed. She threatened me. After that, she filed a false and frivolous complaint against me. Thereafter,
who is representing daughter-in-law?
yes, my lord, I am for the daughter.
Any prosecution has been initiated, Mr. Das?
Yes, there was a FIR which was drawn up and which has culminated into a charge sheet also. Charge sheet has been filed in 2025, 30th of November 2025. So I believe lordship
Cognizance must have been taken by this time.
cognizance must have been taken.
Writ petition is not maintainable.
No, we filed a complaint. The police didn't take an action till date.
His allegation is that the police has not acted on the complaint, which is at page of 29th.
Page 20.
Page 20.
No, on the basis of whose complaint? This
On the basis of mother-in-law's complaint.
Daughter-in-law's complaint that
mother-in-law is
has a
complaint is
counter
not
complaint,
taken,
has not been taken, has been not been registered as a FIR. That is his complaint.
And I am being
So what is your
threatened.
instruction with regard to the complaint of mother-in-law?
Lordship, an inquiry was conducted and prosecution under 126 was given and bound down. The daughter-in-law has been bound down.
Then yes, file your communication.
Regarding
There's
the
a complaint by daughter-in-law based on which prosecution started, then investigation completed, charge sheet filed.
Yes.
So far, your complaint that has not been transformed into an FIR. Certain steps have been taken, but no, it is not a case of registration of FIR according to police authorities. Now, what is your submission?
Your lordship, my submission is I am being constantly threatened. So maybe some protection may be given. Maybe direction may be given to give me some protection.
My lord, para 8 of my of the communication.
Even on 24th May, before me registering the complaint, the respondent with his parents came to my house to threaten me.
But the private respondent is not staying at your residence. So where is the question of granting you protection? I could understand that your daughter-in-law is staying at your residence.
But she.
So where is the question of granting you granting protection by giving direction upon the police authorities?
He comes
Yes, sure.
when my son is. When my son is not home, she comes.
No. Rahul, there is acrimony in between petitioner and her daughter-in-law, namely her daughter-in-law being respondent number 4. which gave rise to a criminal prosecution being Bolagor Police Station case number 403, 2025, dated 17th August 2025, under certain provisions of BNS. Stop. On completion of investigation, charge sheet dated 30 November 2025 was filed before the jurisdictional magistrate. Such prosecution was initiated based on complaint of respondent number 4. Stop. Next paragraph. Subsequently, where is your complaint?
Page 20.
20. Subsequently, complaint was lodged by the petitioner dated 29th of May 2026, and a grievance is and the grievance of the petitioner is taking note of such complaint. Appropriate steps have not been taken by the police authorities. Stop. Prayer is also made for directing the concerned police authorities to provide protection. Next paragraph. However, from the report from communication dated 7 July 2026 of officer in charge Bolagor Police Station, Hooghly, it appears that respondent number 4 is not staying at the staying at the house of her in-laws. Stop. Since petitioner and respondent number 4 are staying separately, there is no need to give direction upon the concerned police authorities to provide protection to the petitioner. As sought for in this writ petition. Next, however, if petitioner is aggrieved by inaction on the part of the concerned police authorities to take steps based on complaint dated 29 May 2026, petitioner shall be at liberty to approach jurisdictional magistrate under section 175(3) BNSS 2023 in pursuit of remedy. Stop. Present writ petition stands disposed of. Parties to act on service. Taken on record করা আছে না করেছি communication dated 7 July 2026 of officer in charge Bolagor Police Station, filed by learned advocate representing or filed on behalf of state respondents is taken on record, and copy of the same is made over to the learned advocates representing the petitioner and respondent and private respondents. Next. Suchitra ji.
160. Item number 164.
Please, my lord.
No.
We have made an addition of party
Lordship, item number 164, I'm being led by Mr. Bhattacharya, Learned Additional Advocate General. If my lord, he's on his legs in another court, if my lord could be.
My lord, I don't think I should trouble your lordship today any further, my lord, ethically. Your lordship may kindly grant, my lord, I should not trouble your lordship today at least ethically, my lord. So your lordship kindly grant me to file an objection to the impleadment application, my lord, what was filed by my learned friend, my lord.
Impleadment application
Filed by him, my lord. He is nobody to the proceeding, my lord. No, perfect. So I will file my objection. I am not arguing that today.
What is the case?
My lord, I am the former chairman of the Panchkula municipality. After, my lord, the change, there are numerous proceedings against me.
How many? 30 or 50?
My lord, I don't have the list, but that's one of the prayers, my lord. I'm deeply obliged. The additional prayer I have, my lord, the restoration of the security cover, which I had and which was endorsed by the Honorable Supreme Court also. My lord, earlier also, once I prayed for, my lord, disclosure.
Who are you? Complainant?
My lord, I have to, your lordship, you have to give me 2 minutes. I will tell you who I am. My lord, this petitioner present here is a murderer of a criminal case, which was one second.
No, no. If you say murderer,
My lord, he's an accused in a
so
302
let's say
case. My lord, 1 minute. I just borrow 1 minute. 302 case where state previous ruling dispensation moved a 321 application for withdrawal of the case. Now, this honorable court interfered with that, said in a murder case, you cannot move a 321 application. This person was so powerful that in a 302 cases, during trial, witnesses were abducted, which led the Honorable Supreme Court to transfer all the cases from the Purbo Medipur to Calcutta. And there was a specific direction upon the court that the trial court will not be even be able to enlarge this person on bail. Only the Honorable High Court can. Now, my lord, thereafter, my lord, what happened? There are many police witnesses started turning hostile, over which a writ petition is pending. And my lord, while transferring the case, the Honorable Supreme Court has held that all the matters will be heard by the portfolio judge.
No, my lord, it was.
My lord,
factually
my lord,
absolutely
that is part of my voluminous.
Maybe that's wrong.
Thereafter, my lord, all the
No, my lord,
Honorable
there is
Supreme
nothing.
Court. Thereafter, my lord, this Honorable Court, pending CRRs and everything, my lord, the Honorable Chief Justice assigned a particular bench where 6 or 7 matters concerning this criminal case was assigned. And 3 of them has been disposed of. 1 is still pending with regard to how this person has influenced police authorities and how this person has obtained the security using his power, being a under trial prisoner in a 302 case. Thereafter, my lord,
Then this writ petition needs to be heard by that way.
yes, my lord, that
They
is
don't
because
want
there is
your
an
lordship to
assigned.
clear the matter, my lord. It's not so at all.
And there
If
is a
that is
player.
your lordship will impose cost against me personally, I tell your lordship. My lord, 1302 case was the subject matter in that writ. Since the matter was in, my lord, Calcutta, so that was the order that in respect of that particular case. Here, my lord, he is a busybody because that matter is not the subject matter at all in this writ petition. It's the only simple prayer I have, my lord. The disclosure and the restoration of the security. Now, what he has, my lord,
if the security has been withdrawn in terms of the order.
No. Or rather, Honorable Supreme Court says that you are under security cover. But sees just one page, my lord, I leave it.
Most of the order he has not included in his writ
page
petition, which
63.
I have incorporated in my
Page 63.
addition of party. So he
And
wants to give
this
a
is your lordship, my
opposition.
lord, if you are making wrong submission, my lord, your lordship will impose cost against me.
And there is
Your lordship will kindly impose cost.
You are opposing his application for
But because he is nobody, my lord, that
He's contesting there as well.
That 302 case is not the subject matter before your lordship. Now they
He refers an order
intentionally
of that court.
want to avoid your lordship's court. I don't know why.
No, I am not.
So then you
I
don't
am.
say so.
No, I have to point out.
whether your implement application is appearing in the list. Yes,
Well, we have been served with a copy.
It is can 1 of 2026.
Can 1.
And my lord, one thing, page 206 of that application I have added that a contradictory prayer is being considered by the coordinate bench.
Well, this subject, this matter,
the particular order of the Supreme Court, based on which security cover was withdrawn.
No, I will show you, Lord.
not a single
One
order,
second.
Kindly, I'm deeply
My lord,
obliged.
kindly comes to page 283.
I'm deeply obliged.
This person has Thrice.
How you are interested so far this matter is concerned?
Yes, my lord. Because,
That
my
is a
lord,
very pertinent.
I will show other prayers, but one thing, 1 second, I am showing. My lord, your lordship, if comes in my addition of party application, my lord, kindly comes to page 206. This is in a writ petition with regard to the police witnesses, including SP turning hostile. Now, in that,
302 case.
that is being contested by my learned friend.
206 is a part of application.
Yes, yes. Part of a writ petition preferred pending before a coordinate bench upon being assigned. There, my lord, sees prayer D. What happened here, my lord, the Supreme Court said that this person will stay in, will not go outside Calcutta. He was restricted within the parameters of Calcutta. Now, while that order was in place, SP Purmol Mednipur granted him security in Kolkata.
So that was never been withdrawn by Supreme
One
Court.
second,
Order. You show the order.
let me place my.
Do you show that order? I'll be out of court. That it was withdrawn by court's order.
This is whose writ petition?
This is my writ petition. He is contesting. Now,
so this is your prayer to withdraw
the security. Now, when he filed 3 relaxation of condition of bail before Supreme Court, saying that let me allow to leave Calcutta, thrice it has been rejected by the Honorable Supreme Court. Now, when the 3rd relaxation application came to before the Honorable Supreme Court, the Honorable Supreme Court posed this question to the state advocate on the basis of what you are providing him in the security. That answer came in negative, which has reflects in page 283 of my application. Para 34. Because on the basis of 2013's assessment, Purbo Mednipur SP gives protection to a person who has been restricted in Kolkata. Well, there are many things I have to show.
34, there are observations which is negating your case.
Your lordship has seen the order dated, my lord.
Justice Dipankar Datta's order.
Sees para 51 of that order, my lord. That order only, my lord. That was a submission recorded, my lord. Now sees, my lord, what was the observation. Well, page will be, my lord. If your lordship is in the CRAN, then the page will be my lord, it will be 292.
My lord will read it as a whole. Including the last line of that paragraph.
Paragraph 34.
Yeah, 51.
51, my lord. Page will be 292.
Supreme Court said that if SP Purbo Mednipur thinks,
Supreme Court has
yes,
said, that's
SP Purbo
mentioned there, sir, you
Mednipur
need not
thinks
interpret.
that there is so much threat perception in Mednipur, then you shouldn't leave Kolkata. That is what has been recorded. Last line.
Yes.
So what
is the
he
rejection
said,
of my condition
one
of
second.
relaxation, my lord.
What
52
because
and 54 is his
Supreme
prayer
Court,
for rejection,
Supreme
my lord,
Court
of cancellation
asked
of bail.
if your apprehension, SP Purva Mednipur assessment of 2013 that you are being provided security, then why would you ask for relaxation?
Supreme Court said that he should not leave Kolkata.
Yes.
There is threat perception, super petitioner is
Purva Mednipur, why will you go there?
So when did
Why
Supreme Court
SP
defense
Purva
assessment
Mednipur?
withdraw the security? Rather said you are
A
protected.
lot
for
has
security
been
in
said,
Kolkata.
Lordship, by the writ petitioner.
This no or yes
The
will
writ
not go. I will file
petitioner
an
cannot
objection to
claim.
writ petition, when this writ petition is being heard by by a coordinate bench, in that event, the present writ petition where you have taken the point of providing security cover and has prayed for a direction. Please, why that writ petition should not be heard?
But that writ
And
petition,
he has not
It should be
disclosed that.
dismissed in limine.
He has not disclosed that
It
because
should be
he is
dismissed in
participating
limine
in
because
that.
the writ petitioner cannot.
may I? Malad, your Lordship, can you
Security
hear me?
cover is no
Malad,
cosmetic.
that-
Passing in order today.
Oh, please.
Security cover is no
Matter is-
cosmetic that he is going to carry on and roam around the entire state wearing that cosmetic.
Representing the petitioner and state respondents, Mr. Nag, learned advocate, represents applicant being Can 1 of 2026, seeking impleachment. Stop. The hearing of this matter stands adjourned. Please.
But can you grant me a chance to file an objection to the impleachment, my lord? Because my fundamental objection that he is no one. Can you grant me an objection, your lordship?
Let me consider, and then
Very
if it is
good.
required,
Very
I will grant you
Very good.
opportunity.
I'm
to use
detailed that I know, my
affidavit
lord.
of
I'm absolutely sure about that.
List the matter under the same heading for further consideration on 14th September.
Most of this.
Grateful.
হ্যাঁ দিয়ে দিচ্ছে